We're live. No, we're just recording. Now we're live. All right. Well, welcome to our first meeting of the interim of the Joint Judiciary Committee meeting. We have an aggressive agenda over the next 2 days. A lot of topics, but a lot of smaller topics. So I think that will help us manage through them. So just bear that in mind as you look at our agenda committee over the next 2 days, and public as well, that there's an awful lot that we have to get through. And this is just our first meeting. So it's really introductory in the next 2 days to our topics. And then over the course of the interim, we'll hone in more on those topics if legislation is proposed to be drafted and advanced on those topics. With that, let's go ahead and call the roll.
Senator Cooper. Here. Senator French. Here. Senator Kolb. Senator Cost.
Here.
Representative Crago. Here. Representative Larson. Here. Representative Oakley. Here. Representative Provenza.
Here.
Representative Washit.
Here.
Representative Rodriguez Williams.
Here.
Representative Yin.
Excused.
Representative Zwanitzer. Co-Chairman Nethercott. Chairman Olson.
Here.
We have a quorum.
Perfect. We like that. Co-Chairman Nethercott, do you have any opening remarks before we begin?
Good morning, everyone. It's wonderful to be here, starting the interim of the #1 committee. Looking forward to the good work that we're about to embark upon. We have a robust schedule, as co-chairman indicated, so we got to get down to business quickly. We have a busy schedule, but I have no doubt that we'll do all the heavy lifting during this interim, and wonderful to see you all again this springtime, and good to be back in Fremont County.
It's always good to be in Fremont County. Thank you, Representative Oakley, for hosting us in your beautiful city and beautiful county. Committee, any opening remarks that you'd like to make? No? All right, you really want to get right to work. All right, we'll get right to work. First topic is trespass. We'll begin with a Legislative Service Office overview. You have 2 memorandums, committee. One is topic specific and one is topic general. We'll begin with, I think what we'll do, David, is we'll go through your general topic, and then we'll have you go through the specific topic as well. And then we'll open up the testimony to any of the trespass topics that you'd like. So the floor is yours, David.
Thank you, Mr. Chairman. I'll start with the memorandum dated May 3rd, 2022, just the topic summary, trespass. This is just basically a general overview of existing Wyoming law related to trespass. It starts with the criminal statutes, of which those begin on the second page. The general criminal trespass generally provides that a person must enter or remain on the property of another knowing he is not authorized to do so, or after being notified to depart or not trespass. That notice may be given personally to the person by the owner, an agent, a law enforcement, or someone, generally someone who has authority to provide that notice, or by posting signs. If someone were to violate that statute, it's a criminal misdemeanor punishable by 6 months in prison, fine of $750 or both. The next criminal one is the game and fish trespass under that statute. And this relates generally to hunting, fishing, or trapping, or collecting antlers. And the primary difference between the general criminal and this particular statute is it does not require that the person know that they are trespassing, simply that they do trespass. And if that person enters private property without permission, with that purpose for hunting, fishing, trapping, or hunting horns, they would be guilty of a misdemeanor up to 6 months in jail, fine of $1,000 or both. There is a specific provision related to trespass or to hunting at night. In order to do that, they have to have written permission from the landowner in order to not to violate the prohibition against that night hunting on private property. Next is a criminal data trespass, which generally relates to a person trespassing on land to collect resource data, including land use data, agriculture, minerals, and natural resource data. That statute forbids entry, and we're moving over onto page 3, where a person, again, well, just to highlight, this statute does not require knowledge or a culpable mental state that they know that they're trespassing. They simply do have to enter onto private land for that purpose of collecting data, resource data, when they don't have their own interest or authorization in that land. This statute does provide an enhanced penalty of up to 1 year in prison, a fine of not more than $1,000 or both, and upon a subsequent conviction, provides a mandatory 10 days imprisonment up to 1 year, minimum mandatory of 10 days, and still up to the 1 year maximum, and a fine of not more than $5,000 or both. One thing to note about this particular statute is part of it has been held to be facially unconstitutional. There is a provision in there specifically relating to trespassing across private land in order to collect that resource data. So you're not trespassing on the land to collect the resource data, but you're crossing it to collect resource data on other land. And that was held to be unconstitutional. So that subsection C that's mentioned is not enforceable, but the rest of that statute does remain.
Co-Chairman Nethercott.
Thank you, Mr. Co-Chairman. Mr. Hopkinson, thank you. And usually we don't interrupt right here, but maybe you want to draw the committee's attention to this issue. Subsection C of this particular statutory section that the 10th Circuit has declared to be unconstitutional, is that still in statute?
Mr. Hopkinson.
Madam Chairman, yes, it is.
So would this be something that the committee could repeal to be consistent with that 10th Circuit opinion, this particular subsection?
Yes.
I look forward to a motion, committee. Thank you.
And Mr. Chairman, Madam Chairman, just to point out, we see the same issue further on in the civil trespass where similar language is used on the civil side of things. So there would be 2 statutes that this applies to. And I'll come to that in just a moment. Going back to the criminal trespass statutes, there is a trespass on a closed ski area, which provides fine-only penalty for an individual skiing on land that's posted as closed, for an individual entering private land from an adjoining ski area when that's posted as closed, or for an individual entering a portion of leased government land, knowing that that area has been deemed unsafe, or signs have been posted warning that and prohibiting entry, which are likely to come to the attention of the public. And that is a $100 fine. Trespassing, and finally, trespassing on land owned by the State Loan and Investment Board, that if a person knowingly and willfully trespasses on that SLIB-owned land and they cut timber, grass, or hay, or graze, or cultivate the land without authority, it's a misdemeanor, subject to a fine not less than $25, no more than $500, imprisonment for not less than 30 days, no more than 6 months, or both. On the civil side, Wyoming does recognize the common law trespass, which generally provides that a person that the plaintiff was in possession of property and that the defendant intentionally entered upon that property. There's, again, is not necessarily, there's not a knowingly requirement. You don't have to know that you're trespassing, but there is an intentionally requirement, simply meaning that you have to have intended to cross into that particular land. But that does not have to mean that you had the intent or knowingly were entering onto private property. An individual who were to sue under this common law would be able to be compensated for any harm resulting from that trespass. And the exact amount, of course, would be determined based on the extent of the harm. For a simple trespass where there's no harm done, there are just nominal damages of less than $100 available. There are some civil statutory trespass actions. And now we're on page 5. The first is the civil data trespass, which is where an individual trespasses across land for the purposes of collecting data, similar to what we discussed previously on the criminal statute. They're liable for all consequential and economic damages as well as litigation costs, liable for witness fees, other expert fees, and reasonable attorney's fees and the reasonable necessary costs of identifying the trespasser and obtaining service of process on that trespasser. Here's where we see that subsection C, which just refers to where they're crossing private land to get to the area where they're collecting that data. That has similarly been held facially unconstitutional by the 10th Circuit. Next is trespass for the with respect to oil and gas operations. And that provides that an individual has to provide minimum notice to the surface owner, have good faith negotiations and the opportunity for mediation or arbitration. And there are provide a surety bond, and there are penalties for late payments of any damages provided for or caused by that trespass, as well as it provides procedures for grievances and appeals, but specifically does not exclude other remedies for someone trespassing for the purposes of oil and gas operations. And finally, there's trespass related to livestock or buffalo that breach a lawful enclosure, and they would be liable for all damages sustained by the owner of that enclosure, as long as that enclosure is a lawful fence or a lawful enclosure. And then on the bottom of page 6, there's some notes for the committee relating to corner crossing. With respect then, moving on to, without objection, Chairman, I would move on to the next memorandum. Okay. Next, there's a memorandum dated May 13th. Topic summary, drones and trespass, and this is specifically relating to those issues of drones as they relate to trespass. First portion of the memorandum provides just some background information on drones or unmanned aircraft systems, unmanned aircraft vehicles. They've got, I'll refer to them as drones. They are subject to regulation by the Federal Aviation Administration to ensure the safety of flight and safety of people and property on the ground. Congress has the authority to regulate air traffic, and they have specifically provided legislation relating to drones. Beginning in 2012, they provided this through the FAA Modernization and Reformed Act, and they continue to legislate in this area, and that legislation is very much ongoing. Congress has asserted that authority to legislate in this area through the Commerce Clause, providing them the power to regulate commerce with foreign nations among the several states and with Indian tribes. Generally, courts that have considered, or courts consider state or local regulations of airspace have ruled that the federal government occupies the field of aviation safety and the efficient use of national airspace, and they have generally struck down state and local aviation laws as field preempted. In 2015, the FAA did provide a fact sheet that simply provides some examples of laws that the FAA might find more problematic. And those specifically are restrictions on operational restrictions, flight altitude, flight paths, just general outright bans, operational bans regulating the navigable airspace and mandating specific equipment or training may be preempted. Whereas the general police powers of the state, such as land use, zoning, privacy, trespass, and law enforcement operations would not be. There have been some questions as to Congress's authority relating to drones, and that area I think is still somewhat unsettled. Specifically, they've called into question how far down in space or in the airspace that Congress can regulate. There is highlighted the case of the United States v. Cosby, which was dealing specifically with airplanes flying low over private property that were preventing the owners of that land to use it in the manner that they had been using it. And that case essentially found that landowners, they own and have exclusive control over the immediate reaches of airspace. This is still somewhat specific limits on the authority here are I think still somewhat up in the air. Moving on then to the specific FAA regulations relating to drones. One area in particular known as Part 107, I think applies to what we would more commonly think as drones, specifically drones that may be more common, particularly in use by the public. And these would be small unmanned aircraft systems or drones, those that are under 55 pounds. That weight limit includes anything that's attached to the drone as it's flying. Generally speaking, these regulations would be licensing requirements, maximum flight altitude of 400 feet above ground level, that they fly only within the visual line of sight and during daylight hours, and that there are no flights over persons who really aren't participating in the flight of that drone. Those specifics, again, are being changed and still those regulations are being modified currently. Recreational flyers don't have to necessarily follow all of Part 107, but they have similar restrictions. And all drones that are over 0.55 pounds, in other words, over slightly more than half a pound, must be registered with the FAA and display that registration on the drone itself. FAA regulations generally for drones that are over 55 pounds or used for commercial purposes have much stricter requirements for licensing, inspection, certification, and generally aren't available to the public absent an exemption. And the FAA is finalizing and I think may have finalized and is in the process of implementing requirements that all drones provide a remote identification system. This would be in place by September 16th, 2023. And that ID system would transmit a unique identifier for the drone, its latitude, longitude, geometric altitude, velocity, and the location of the control station or the takeoff location. At least 44 states, including Wyoming, have enacted drone-related laws. These commonly include defining what a drone is, the use of it in law enforcement or other state agencies, how it can be used by the general public, and regulations related to hunting. As far as trespass goes, we're over on page 7. There have been a number of efforts to kind of highlight, to make uniform specific regulations relating to trespass. The Uniform Law Commission, from which we get a number of model laws, made an effort to do so in 2018. They had a draft that would have required any non-consensual flight below 200 feet to be deemed a trespass. They ultimately moved on from that draft and in 2019 considered one where a trespass would be if a drone were to interfere with the use and enjoyment of the private property. Ultimately, they have not adopted any drafts, and at this time, it's my understanding they aren't considering the issue. Looking then to the common law of things through the restatement of torts, there are two potentially applicable civil trespass provisions. One is just the general civil trespass that we discussed in the previous memorandum, that a person enter on the land in possession of others, that they remain on that land, or they fail to remove from that land a thing which is under their duty to remove. That may be applicable to drones. There is a more specific section related to aircraft, where that trespass, if that aircraft were to enter into the immediate reaches of the airspace next to the land, and it interferes substantially with the user's use and enjoyment of that land, that section may be applicable. There is a Wyoming statute in 10.4.303, which is part of the Uniform State Law for Aeronautics, that prohibits aircraft flying low, but that statute does specifically exclude drones under 55 pounds, which would be the small drones. And so I think it's an open question if that would preclude regulation of flight-related above the ground type regulations, and how that would apply to smaller drones, I think is a little bit up in the air. One other specific tort Wyoming does recognize is the common law tort of intrusion upon seclusion, and that may be applicable to drones. That specifies that one who intentionally intrudes physically or otherwise upon the solitude or seclusion of another or his private affairs or concerns is subject to liability for the invasion of that privacy if the intrusion would be highly offensive to a reasonable person. So again, that may be applicable currently in Wyoming to drones. There are at least 10 states that have adopted legislation regulating the use of drones in hunting activities, and generally those limit or prohibit the use specifically for things such as locating animals, hunting animals, things of that nature for the use in trapping or fishing, as well as there are commonly regulations that prohibit interfering from a person who is currently hunting, interfering with their hunt through the use of a drone. With that said, Mr. Chairman, I would stand for any questions.
Thank you, Mr. Hopkinson, for your work on both of those memos. Very thorough and hopefully a good start to the conversation as we drill down deeper into what this committee is interested in on the trespass. Questions, committee, for Mr. Hopkinson? Co-chairman?
Thank you, Mr. Co-Chairman. Mr. Hopkinson, the restatement 159 of torts looks somewhat promising. Would that run afoul of federal law? Would we have the authority to enact that?
Madam Chairman, I think it would kind of depend on how we got that. If we were to enact specifically as it's drafted in the memo, it's not a regulation. I guess when you look at what the FAA has recommended not regulating those, it would include the specific restrictions on flight altitude, paths, that sort of thing, but they have left open certainly trespass type regulations, and I think this could fall under that. So I can't say with certainty, because obviously there's always somewhat a level of uncertainty, but I think it's likely that could be enacted without an issue.
And then one more follow-up, Mr. Co-Chairman. Mr. Hopkinson, if we were to repeal the sections in our statute associated with digital trespass that the 10th Circuit has declared to be unconstitutional, would we need to do other work with the other sections of the statute if we just were to repeal those provisions, or does that lead to an absurd result? We're not looking at it as broadly as perhaps we should.
Madam Chairman, the subsection that has been held unconstitutional, I think is severable from the rest of that statute. So I don't see an issue with just repealing that particular section. There may need to be some conforming amendments. I'd have to take a closer look, but I don't think there's just an issue on its face from just repealing that section.
All right, thank you.
Mr. Hopkinson, just as a follow-up, I'm just curious if, and maybe you didn't look into this, but maybe we could. I'm just curious why we haven't touched that then since the opinion. Other than because Chairman Nethercott wasn't the chairman at the time, so we may have been a little more loose and relaxed, negligent.
Mr. Chairman, there were, I believe, discussions previously with the Judiciary Committee about this issue, but I don't think that there was an action taken by the committee. As for why that was, I couldn't say.
Yes.
Thank you, Mr. Co-Chairman. I think the issue was pretty sensitive to the legislature at the time. The law was put forward pretty passionately regarding this digital trespass concern by many major landowners. And then as soon as the law was passed, it immediately reached litigation. And primarily the plaintiffs were suing the state of Wyoming, were many out-of-state interests, and the law was declared to be unconstitutional almost immediately. The legislature tried to go back and fix it unsuccessfully. Obviously, the provisions still stand that have been determined to be unconstitutional. And the federal court levied significant attorney fees against the state, which the taxpayers had to pay to out-of-state lawyers to recognize that concern over the legislature creating unconstitutional laws. So it was a pretty touchy subject there for a while. before I think many of us here were in the legislature.
Why do I feel like Representative Wanitzer, you lived through that in firsthand experience?
Mr. Chairman, I did, and I was one of the 5 no votes on the bill in the House that said it was unconstitutional and got my tail handed to me at the time. Only 3 Republicans and 2 Democrats said we can't do this, and no one else wanted to listen to us at the time. But so when the time for that motion comes, I would be happy to bring it since I've been living under it for 6 years. But my question, when we talked about the 10 states who have trespass laws in regards to hunting with drones, is there a model act in that regard, Mr. Hopkinson, or is there a state? I think that's my most passionate issue, is to really get one of those on the books in Wyoming. And do you know if there's a model act or which state would be the best for us to model a bill draft after?
Mr. Chairman, Representative Wanitzer, I'm not aware of a specific model act, but I do believe that the legislation in those states is fairly similar. Because it's fairly straightforward as far as the limitations on their use in hunting and that sort of thing.
Representative Craigo?
Thank you, Mr. Chairman. Mr. Hopkinson, don't we in Wyoming already have a statute regarding hunting with drones?
Mr. Chairman, Representative Craigo, the Wyoming statute uses the term aircraft, is my recollection, and would be happy to look into this more thoroughly for you. And that the term is not defined. So whether or not it applies to drones, I think is an open question, because a drone being an unmanned aircraft, does it fall under the definition of aircraft? Or, well, there is no definition of aircraft, it's just lists aircraft. So I think that's a good question. Certainly something that perhaps could be made more clear if that's the route the committee wishes to go.
Senator Cost?
I know we dealt with horn hunting and drones in the previous judiciary meetings. I don't know how far that, I can't remember how far that went in session, but I know there was a concern of bothering animals by drones, keeping track of where they're going so that they'd know where the horns are and that type of thing. And so tracking for that, I know we had quite an extensive discussion on at one point, but I don't know exactly where that falls right now as far as the statute. I do have one other question, and it doesn't apply to drones, but with the number of subsections of land being broken up into different parts, spraying on fields and crossing over other areas, how does it relate to the protection of the people that are spraying crops and all and have to fly over different people's lands to drop in on the land that they're spraying? Is there anything about that, or can they end up in trouble on this? I just wonder where that goes.
Mr. Hopkinson?
Mr. Chairman, Senator Cost, I don't have that information offhand, but I could certainly look into that for you.
All right. Mr. Fuller?
Yeah, Mr. Chairman, just in response to Representative Craigo's question, there's 2 statutes that may be applicable. The first is 23-3306, and that's the statute Mr. Hopkinson referred to regarding the use of aircraft. There is another statute, 23-3407, which prohibits remote hunting. And I'm not sure if that statute would apply to drones or was intended to apply to drones, but it does say that you cannot operate or use any computer software or service that allows a person not physically present to remotely control a firearm or weapon.
Anything else, committee? Okay. Representative Craigo, please. right in the center.
Thank you, Mr. Chairman. Committee, Madam Co-Chairman. So I had asked for this particular topic to be put on our committee's work for the interim. I had sponsored a bill, House Bill 103, regarding trespass to hunt. And it essentially what it did was change the language a little bit in statute 23-305B. And due to a lack of timing, et cetera, budget session, we didn't really get to address it in session this last time around. And so, first of all, let me say, it's not a corner crossing bill. I'm not trying to deal with corner crossing, which I've received thousands of emails regarding that since during and since session. And I don't think that's actually, I'm personally, and the committee may feel differently, but I don't think that's necessarily something we can fix at the legislative body. I think the courts are going to have to decide that, because no matter where it comes down, it's going to end up back in the courts, whether it's a takings case or a prohibiting access to federal lands or public lands, et cetera. I think the courts are going to have to decide that. And so I'm not trying to tackle that. I don't want to tackle that. That's not the problem I'm trying to address. The problem I'm trying to address is under the trespass to hunt statute, it's applied differently throughout the state. And we have various degrees of how it's implemented by our local game and fish employees. In some places, just driving through private property, through deeded property, does not qualify as a violation of that statute. In other places, it does. And so in certain places, for example, my home county, we don't necessarily enforce that statute if someone is just driving through private property to get to other property to hunt. And if you look at the language of the statute, that's a fair reading of the statute. Other places read it not quite as literally as that, and believe if you're simply driving through private property, for example, to get to BLM or state property, that qualifies. The problem is typically in the field during hunting season or during shed hunting season, game and fish officers are the only ones really in the field. And so they can't write tickets under the criminal trespass statute. And they rely on this particular statute to enforce trespass. The problem is the way it's written and the way it's interpreted by some of our local agencies is they can't write the ticket. What I'm trying to do is clean it up so that even if someone is trespassing to get to public property, they would still be eligible for a ticket under the hunting trespass bill or hunting trespass statute, excuse me. And so that's simply what I'm trying to do. Make it a uniform application across the state, give our game and fish officers the tools they need. Because, for example, in my county, if someone's 2 hours from town and game and fish find somebody trespassing, they can't necessarily write the ticket. They call the local sheriff's office, who isn't super excited about driving 2 hours one way to the nether regions of Johnson County to write a ticket, a small misdemeanor trespass ticket. And usually it just doesn't happen because they don't have the manpower, they don't have the resources to do that. And it's a shame when somebody's already in the field, they could take care of the problem. And I think, we're not trying to restrict legal access to public land. That's not what this is about. This is just trying to protect private property rights and make sure that we can write tickets when we need to, give our game and fish guys the tools they need. And they will still have the discretion to not write a ticket. If someone's accidentally there, game and fish, our officers can figure that out. They can write them a warning. They can say, hey, you shouldn't be here. But when they see somebody trespassing multiple times, then they can do something about it. And I think they're good about that. They use their discretion wisely, and I trust that they would continue to do so. Just to speak about the drone issue real quickly, Representative Summers had asked that this be one of our topics as well. He had sponsored a bill, I believe it was House Bill 128 during the budget session. Same problem, we just didn't get time to get to it. And I think the problem he and a lot of us would like to address with that particular topic is we see too many drones flying around people's houses, in town, out of town, et cetera. I think that's really the invasion of our personal privacy is really what we're trying to get to there. I think that was his intent, and I would like us to draft some language, draft a bill that really addresses that particular problem, which is invasion of our personal privacy. And if we need to clear up the hunting, protection of wildlife, et cetera, we could do that. There's lots of model language within the materials that LSO has put together for us. And I think we can use all that to move forward. And I stand for any questions. Thank you.
Representative Craigo would be the shortest bill ever. When a drone trespasses into your property, you can shoot it. It's like a pretty easy bill.
Mr. Chairman, I would love that. But I believe LSO will tell us that we cannot do that. That's where we would be preempted by federal law. I'm up for it, the fight, but I don't know if we can get away with it.
I like a lot of what was just said. Representative Provenza.
Thank you, Mr. Chairman. I believe that potentially we could use our no duty to retreat to shoot a drone, as in they could be dangerous in our yard. However, I do want to ask, with the bill that was brought forth, House Bill 128, it brings in just a new statute, criminal trespass by drone. What are your thoughts on potentially include like amending harassment or stalking or voyeurism and those other statutes to ensure that they include drone use, so that the act of using a drone for harassment or any of those instances is criminalized, rather than potentially bringing this in?
Representative Craigo.
Thank you, Mr. Chairman. Representative Provenza. I think that would be fine as long as we get to the end goal of if we can solve the problem by amending other statutes, that's fine. Other states, looking through the LSO materials, other states have done that. There's different ways to attack the problem. And I think however we do it's fine. Would not matter to me. Mr. Chairman, if I might go back to my original topic. So I would say I received lots of great comments once I brought forth House Bill 103. And, one of the concerns, and I think we'll have to address this, was the way I drafted the bill. People were worried, for example, that if you float down the river and you're in between two pieces of deeded property, is that a trespass? No, and we're not trying to get there either. So we're gonna, as we work through this with LSO, I think we'll just have to carefully craft the language so that we're not creating instances of trespass that we were not trying to do. I'm not trying to restrict any other access. I'm just trying to clean up a statute we already have. And that was really my hope. And there's a couple other little things that I'm sure we'll hear comments on and testimony, which are going to be helpful to us as we make our decisions moving forward.
Committee, additional questions for Representative Craigo? Yeah, Vice Chairman Washut.
Thank you, Mr. Chairman. I'm just a little curious about your comments on corner crossing being resolved in the courts. And I guess my question is, if this is in fact going to go into the courts for ultimate determination, which is likely, would it not be beneficial for there to be statutory language in place that says where the legislature comes down on this issue, one side or the other?
Representative Craigo.
Thank you, Mr. Chairman. Representative Washut. I'm not sure that's going to be helpful. Unconstitutional is unconstitutional. If I think you're talking about two competing constitutional rights here. One is right to private property, deeded property, and is it a taking? For example, if we say that you can corner cross, and the other one is the public's right to access public property. And I think those two interests, either, no matter what if we say as a legislature, if we can come to some sort of consensus, which I'm not sure we can, but let's assume we could, no matter what, the court is going to end up making that decision one way or the other. And right now there's a case pending. And I think we'll get an answer from our federal court here shortly. I mean, will it be a year from now? Most likely, but I mean, in the overall scheme of things, that's pretty quick. That's quicker than we're going to get an answer. And so I would say we wait and see what the court decides and then maybe move forward. If we have to do something different, or if we feel as a state that we don't like that answer that the court gives us, then we can try to do something different. But at this point, the court has it. Let's let the federal court decide and give us an answer.
Committee, anything else for Representative Craigo? All right, there's 4 or 5 more trespass topics if you want to ask him about them. Skiing? No. Thank you, Representative Craigo. All right, we do have a sizable amount of people in the room who may want to testify. I know I have a good chunk of people who are signed up online. What I actually want to do, public and committee, is break down the topics. So I think that's more helpful for the public listening, and bless the hearts of our journalists who are trying to report on this. If we're talking about corner crossing 1 second, and then a minute later, we're talking about drones, I don't want any of that to be confused on what the legislature is or isn't talking about, or is or isn't doing. So let's just maybe take it by topic, public. So it seems like right now there's a lot of discussion on the game and fish, hunting, and drones. And I think that's where we'll start. We'll start talking about those topic areas. If you wish to testify specifically on either one or both of those areas, you're still welcome to testify on trespass in general, but just know I'm going to go through the topics, and I think keeping that organized will be a little more helpful. Drones and hunting online. If you're interested, raise your little hand now, and then we'll let you in. In the meantime, we'll go to the room. If you're interested in testifying either one of those trespass topics, come on up. No? Yes.
Mr. Chairman, Committee, Brett Moline, Wyoming Farm Bureau Federation. I'm sitting in support of taking these issues forward. Visiting with my members, I have to ask, which topic are we on? I'm easily confused.
That's all right. So am I. We are honing in on drones and the hunting, game and fish broadly trespass.
Okay, thank you, Mr. Chairman. Encourage you to take these forward. This is becoming more and more of a problem with the drones. Visiting with one of my members, they could hear a noise and all of a sudden they look out, well, there's a drone. And they don't know why it was there. Were they just looking around? But given what had happened to some of the neighbors, they come around, they fly their drones, they look inside the buildings if the doors are open. If nobody's home, if they don't see any people, that gives them the audacity to then come do what they want because they don't see anybody there. Having this as a specific penalty, I think you're not going to stop it, but I think it will strongly discourage it. And hopefully we can come to a way where to protect the private property rights. In reading some of the information, is it invasion of privacy? Is it trespassing? I'd say yes, it's both. So I'd encourage you to take that forward to strengthen this, but to get it so it is prosecutable. I don't know if that's a word. It's a Moline word now. It isn't in the dictionary. But to take this forward to strengthen the private property rights, the trespassing through somebody's property to hunt, I think needs to go forward to strengthen that. So many times, I'll use an example, what happened on my brother's property. There's a road there. And so many times people see a road in GPS, you see a road, well, it's a good road. It must be open to the public, even though there's signage there. may go through it. So to be able to have the authority through the courts to prosecute those people that are doing that, I think is a great idea. It's a protection of the wildlife, but mostly it's a protection of private property rights, something that's very important to my organization. With that, Mr. Chairman, I'm doing my best to be brief, and as you know, have heard me before, I'm not good at it. So I will sit there, I will stop there, and I will sit for any questions the committee may have.
Where do they have drone issues in Aladdin?
Mr. Chair. You got me, sir. It's not often people can make Moline speechless, but you done it. Yes, it's becoming more and more of an issue. You know, as they become more powerful, Aladdin, well, now they changed the population from 15 to 19. Somebody's dog must have had pups, but anyway, you know, as we get more people, the sophistication of the drones improves. It's going to be more and more of a problem. And I think not only making the statutory laws, but also the information, getting that out to the people. You can't do this. This isn't right. But I will say it's the minority. But that's what every rule, every law, every regulation we have is against what the minority will do. And that's what we need to protect ourselves. But yes, sir. Again, not being very good at brief. Yes, Aladdin does have some issues with drones.
Committee? Any questions? All right.
Thank you.
Thanks. Appreciate it as always. Anyone raise their little hand in the
Mr.
big
Chairman,
virtual world? Yes.
Mr. Chairman, we have Steve Klein from the Wyoming Liberty Group and Byron Odekoven.
All right. Go ahead and just let them both in. We'll let them spar. No, I'm just kidding. Whoever comes in first, I'll take up first. Mr. Klein, welcome.
Thank you, Mr. Chairman. It's great to see you. Hello to the committee. My name is Steve Klein. I worked for the Wyoming Liberty Group full-time from 2010 to 2015. And since then, I have been an out-of-state lawyer in Washington, D.C., and I bring free speech litigation nationwide, 2 different lawsuits against the state of Wyoming right now relating to election law that thankfully this committee doesn't have to deal with. Having said that, this is kind of a blast from the past, and I do think it's a bit humorous to have Mr. Odekoven going to join me digitally. This is 7 years ago in the 2014 to 15 interim. The committee considered the idea of regulating law enforcement use of drones. From that emerged the Wyoming Drone Protection Act that did eventually fail after passing the House. And then the issue sort of disappeared. It's kind of come around again now, but it seems to have been about 7 years without regulation. I think for trespass purposes, it's important to, just as important, if not more important, to regulate government use of unmanned aerial vehicles or unmanned aerial surveillance as it is to regulate private use. With that said, it's clear the research I've done in preparation for this committee and the memo I've provided, it shows that we don't really know how law enforcement has developed or government use has evolved. We only have sort of some understanding of that. And I think it would be important and behoove this committee as it moves forward, perhaps for the next committee, and we'll undoubtedly hear from Mr. Odekoven now, but to find out just what's going on. If the only indications are that drones are being used for search and rescue, things of that nature, it may not be that big of a concern. But having said that, some people, I think, may be under the impression, citizens certainly, that the government needs to get a warrant before they throw a drone over your backyard or your private land. And that's simply not true. That was the entire impetus of the Drone Protection Act back then. And that's the idea, though. Just because the Fourth Amendment doesn't require getting a warrant, state law can certainly put those requirements onto law enforcement. As to whether that's necessary, I think it's really just strictly up to the committee to maybe make those inquiries. You could ask the county attorneys, well, what kind of, if they've had to proffer that kind of advice to law enforcement, the Attorney General's office, the same thing. And of course, now we'll hear from the Association of Sheriffs and Chiefs of Police. We might have some more information right at the outset. So again, this is an old issue for me. I think it's fun to revisit and to see this coming up to head. And I think it's nevertheless very important. And I will sit for questions.
Committee, do questions for Mr. Klein? Representative Provenza.
Thank you, Mr. Chairman. Thank you for joining us today, Mr. Klein. I didn't get to know you during the previous sessions, but I do recognize you from Into the Storm on HBO. So it's nice to have a guest here today that has some fandom. I appreciate the memo that you sent us on the government regulation of drone use. I'm wondering what your organization's thoughts are on the use of private drone use, given the use that they've used with cameras recently.
Mr. Klein.
Mr. Chairman, Representative Provenza, again, I mean, as far as my organization, I still work as a lobbyist for Wyoming Liberty Group, and it is a think tank, and so I don't really speak for my organization. I'm just Steve. They let me have thoughts, write papers, memos, and speak from a position of founding principles. And so my position is, that I noted this in the memo, is that I think the bill introduced, or at least sponsored by Representative Summers, I think it was great because it lacked in the First Amendment problems that we saw in the trespass to collect data law. I think it's a good law. I think the concerns presented by LSO as to FAA preemption, they might be there. I'm optimistic that they're not with the 200-foot floor. Moreover, the FAA does come into play when you're dealing with larger drones. Again, with the limit of half a pound, there's fortunately very limited, and I think it's worth noting that the wind in Wyoming probably interferes with a lot of efforts. You really have to have a low wind day before a drone that's only half a pound is going to get around efficiently. But so I would support that bill. I don't see any First Amendment concerns there. And generally speaking, I think it behooves the committee to move forward on that bill.
Mr. Klein, the wind finally explains those drones in my tree. I just thought it was bad piloting, but it must be the wind. Any other questions for Mr. Klein? All right. Thank you, Mr. Klein. We appreciate you joining us.
Thank you.
We have there's Mr. Odekoven. Welcome, Mr. Odekoven.
Thank you, Mr. Chairman. Byron Odekoven, the Executive Director of the Wyoming Association and Sheriffs and Chiefs. Thank you for the opportunity to offer a few comments this morning on trespassing and as it relates to the use of drones as well. As was described by both Representative Crago and Representative Moline from the Farm Bureau, law enforcement would welcome the clarity on how best to deal with trespassing on the issues described, especially, and accurately so, Game and Fish has a very narrow authority for trespass. When they are, as a peace officer, encountering trespass without their authority, they cannot issue that citation, as we heard. And it would be beneficial in the long run for both the public and for public safety to be able to have the Game and Fish be able to do trespass for hunting and trespass, additional trespass as well. As we heard, it would save quite a bit of effort and probably educate some of the public who know the limitations of Game and Fish versus their local law enforcement. So welcome the county attorney's perspective on how best to proceed with trespass in that regard. In terms of trespass generally, Wyoming has a very finite view, if you will, on trespass in that you must receive notice. So that person you find standing in your yard, your pasture, by your buildings, by your whatever, there's a degree of notice that the statute implies or intends that you deliver. So on one hand, it's kind of like the first offense is free. You're there, you're found, you're noticed, you leave, you come back and receive your citation. So there's some concern that for some of these trespass offenses, folks received that first bite of the apple well before they received that citation to appear before the judge and explain their activities. So that is of concern and maybe worthy for the committee to discuss a little bit in terms of how that goes. Other states, I would caution, require part of that notice to have those no trespassing signs, or as we debated a little bit during the last session, the idea that you would have a tire strewn over every sixth steel post along your property line saying no hunting. And I would hope for the beauty of Wyoming, so to speak, that we wouldn't end up with a whole row of fences with tires strewn over them saying no hunting, and the idea of providing notice. So a degree of caution there as we talk about some of the notice issues that are concerning in at least other states. In terms of the trespass across property, while I'm sensitive to the idea that the courts will determine our level of trespass and whether or not the law is specific, it may be worth at least checking on to ensure that somehow we craft the statute clearly. We talk about trespass for hunting. We talk about trespass criminal with notice. So do I direct or read that if as long as the company has someone trespass and go across the 5, 10, 15 miles of private property to get to the other side for whatever their reason is, that as long as they keep sending a different person who has not received their prior notice, that they can just keep sending someone to trespass across that private property. So of concern on how we word and craft part of that. Lastly, in terms of the use of drones, and thank you to Mr. Klein for referencing our robust discussion 7 years ago when we were sorting out the discussion of the sky is falling, law enforcement is going to have drones and they'll be trespassing everywhere. The testimony that was offered at that time on behalf of law enforcement was that law enforcement would be constrained by the Supreme Court's discussion of lawful presence in plain view and fall under the rules of the FAA. And I think it's demonstrated over the course of the last 7 years that that's where law enforcement lands. And so we do not have instances or reports of nefarious activity by law enforcement by drone. But we're here to discuss today citizenry who is not bound by some of those standards, who are in fact trespassing via a drone, or maybe, depending upon what you choose to pass in terms of statute, that needs to be discussed and brought to bear in a statutory form so that we don't encounter those drones as was described by the bringer of the bill during the session, that to look out your kitchen window and find a drone staring back at you is not what we anticipate should be happening in Wyoming. Likewise, in terms, as I mentioned earlier, our constraints, were we to ask law enforcement their use of drones, predominantly it is search and rescue, the fire department, in viewing of fires. And I'm aware of at least one water district who's using a drone to fly for water rather than drive the ditch. They're able to save a considerable amount of time and effort utilizing the drone to be able to do that rather than drive. And I sense as $6 fuel is in our future, that folks will explore more of the use of drone to be able to do those kinds of activities. So, Mr. Chairman, we look forward to working with the committee and especially with the county attorneys as we sort out some of the nuances to a trespass statute that would cover the competing issues and address the concerns. Mr. Chairman.
Mr. Otakoven, I don't know how much information or knowledge you have of this, but want to go back to conversation that Senator Cost had with LSO regarding the use of unmanned aircraft for scouting of sheds. But I'm more curious just on the hunting site in general with our statute and its use of the word aircraft. How do you know what experience Game and Fish has with that? I mean, how often do they issue citations, if at all? Do you know, Mr. Odekoven?
Mr. Chairman, I do not have any specific knowledge, nor have I requested that. May be worthy of posing that question and learning the answer. I would suggest that the use of drones in scouting for hunting purposes, although sheds is slightly different, but for hunting purposes, other states are looking at that as an unfair practice for hunting, much as some states have outlawed the use of or specified for fly-in hunting, where you're flying into the remote area that you can't hunt on the same day that you fly in, with the idea that you'd be spotting game on your way in, so to speak, and have an unfair advantage then of where to immediately go look in that same day arena. So I think there is some opportunity there for the committee to explore with the Game and Fish on how best to proceed with both adding drone to the word aircraft may or may not help simplify that issue going across.
Just as a follow-up, I guess maybe you would know if, and we'll ask Game and Fish, but if Game and Fish weren't contacted for the use of that drone, is it possible that the sheriff's office would be contacted? Do they get reports at all, calls in for people using drones hunting, or does everyone know? They just know what to do when that happens and they go straight to Game and Fish? Or is it just Game and Fish sees it? Is it really not a public reporting on it?
Mr. Chairman, I would sense that in terms of Game and Fish violations, generally, the call comes into the sheriff's office to dispatch, if you will, and dispatch then proceeds to notify Game and Fish. Some of the violations go directly to Game and Fish and are dispatched out through that system, but generally, by and large, local landowners contact the local sheriff's office to seek a remedy to that trespass issue that you're describing, and are either referred to Game and Fish or a deputy in fact handles that situation.
Hey, Emily, do we have somebody from Game and Fish? I'm assuming we do tomorrow, but not today. Representative Larson?
Mr. Chairman, I just contacted the director and it sounds like they might be trying to get somebody.
Awesome. Thank you. You bet. Appreciate that. All right. And if they show up, let them in. Let me know anyway, and we'll at least move forward. But hopefully we can get some of their insight. If the committee's desire is to touch any of that, I think it's definitely helpful. Well, I mean, I think there's going to be a desire to do something with Representative Crago's bill, and you would think they would want to be here to testify on that. So thank you, Mr. Odekoven. Other questions for Mr. Odekoven? Yes, Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Thank you, Mr. Odekoven. I have a few questions for you. So I've personally seen drones used to track grizzly bears in my neck of the woods when there's a belief that there's bears on some property. But I also live in an area where there's a lot of tourism and encounters with wildlife. And I noticed that some states have statutes that prohibit the use of drones for harassing or in a sense, they use them statutes to protect wildlife from drones. I'm just interested if you think there's a need for that. And then my second question is, it goes a little bit off the hunting topic, but being that we're talking about drones, just curious if there's law on the books to your knowledge or need for law where we could prohibit drones to be used to transfer or deliver Schedule I drugs.
Mr. Odekoven.
Let me start with tracking bears, Mr. Chairman.
Okay.
And I think in tracking, tourist tracking of wildlife generally, I think you have to look at the context of where that's happening. So in the public areas where the public has free access, the question then becomes, can they then have free access with their drone? Generally speaking, you can go to the park, you can go to the lake, you can go to that public area and fly your drone publicly without any restriction. And that becomes part of the question for the committee. And I think it was alluded to earlier with when you transition from that public fly, public view to invading someone's personal space and how that may fit in that arena. In terms of harassing livestock, as drones become more available, I would think that we would want to have something in the statute, and especially in that public space, that you can't use a drone in such close proximity that you would be harassing livestock, or I mean, wildlife, excuse me. So I think that would be beneficial to do. If you think of it in terms of the Game and Fish already closes area to public access to protect calving, birthing, migration to some extent, areas, it would likewise be unreasonable to be flying a drone into that area in close proximity as well, because that too would interfere. So I think there may be value in looking at harassing wildlife and or livestock each in terms of use of drone in the public areas especially. And then as you migrate onto private property, I think you may be covered with someone coming off onto private property through the use of a drone. I would hope would be trespass, as the final review of the bill would bring out. Let's see. And your final one had to do, I apologize, I forgot the final one.
Schedule I drugs.
Oh, thank you. For the delivery of Schedule I drugs. I'm not sure that we would need a specific statute for drone to be able to do that, specifying that the drone, because the operator of the drone would in fact be violating the law on its face. So I'm not sure that we would have a separate statute for the drone that wouldn't already take into account the operator of the drone. Having said that, I know other states are wrestling with delivery of narcotics in the prison setting, with people flying over the prison and dropping narcotics onto the courtyard, game yard, and they're having to do additional fencing to help stop that activity. So I would have to explore that a little bit to see if there was a need to be able to craft something like that for us as well.
Follow-up, Representative? Well, I'm awfully curious, Mr. Shannon, Director Shannon, on the use of drones, but at your facilities. I think so, yeah.
Mr. Chairman, Madam Co-Chair, committee members, I'm Dan Shannon with the Department of Corrections. Mr. Chairman, there's currently laws are not protecting the institutions as far as drone use. There is aircraft regulations through the FCC and such is defined by aircraft, but there is not with drones, and we do have issues with drones being utilized on our facilities. And I would ask, as the bill moves forward, I was going to testify to look at some protections. I'm active with other Western directors as far as electronic use for safety purposes, and I think it really ties in with governmental use of drones. Drones are being utilized by correctional officials across the nation now to help with safety. Examples would be, we do a daily check on rooftops, things of that nature. We send an officer. Now we can utilize drones. So it's a two-way street, but we do have issues with drones being utilized. And we do not have any authority to stop that. We do for aircraft, but not for drones.
So Director Shannon, you're talking about a private citizen's use of a drone near and around over your facilities?
That's correct, sir.
And you said that you don't have any authority. What do you do when you see a?
We try to, Mr. Chairman, we try to secure the area as best as possible. We don't have the authority to stop the drone.
So, okay. So if we, help me walk through this, if we have legislation defining that as a trespass, then what do you believe would be different for you in that scenario?
Well, we'd have an opportunity to contact local law enforcement and enforce it. Right now, we don't have that authority.
Okay, so maybe that, back up to that then. I guess that was really my question. You have contacted local law enforcement before, and that's the response you get is there's nothing we can do.
That's correct.
And I'm assuming, I don't know, I guess I'm assuming the individual may not be that far away from the facility, so they would be able to locate who that is who's using the drone.
Yeah, we've made those, Mr. Chairman, we've made those attempts, yes.
Okay, nice. Yes, please.
Thank you, Mr. Co-Chairman. So in response to law enforcement saying that they can't respond, isn't it true that, caution,
Madam Chairman, if I
sorry,
may.
I revert back that, but isn't it true that it's more probable than not that criminal activity is underway if there's ever going to be a drone over a prison and it's likely transporting illegal drugs?
Madam Chair, from my perspective, yes. And I would like to clarify, law enforcement has responded. It's just the enforcement of such is difficult. It's my belief if a drone's flying over an institution, it's purposeful for legal activity.
Director Shannon, does the FFA prohibit the flying of drones over state correctional facilities or any correctional facility?
Mr. Chairman, they do not. And I keep updated on that. They do not.
Mr. Co-Chairman,
Yes.
have the correctional facilities across the country written the FAA for such protections?
The Correctional Leaders Association, which would be an association of correctional directors, have testified in Washington just this past March on behalf of it.
We're cutting edge.
We are. Well, that's not unusual, but make a little, yeah. Representative Provenza and then Representative Rodriguez Williams.
Thank you, Mr. Chairman. And this is just a note from personal experience. So I own a drone. I have almost brought it for us to have a lunch activity. But in the use of the app, there are red areas. So if you're flying that drone, it'll say you cannot fly over DOC. You can't, it has the jails marked, it has and it cites a law, which I don't remember off the top of my head, but I mean, I certainly believe you in that there isn't a protection. But people do know that they're violating something as they're flying over, if they didn't build their own drone, I guess. Anyway, that's just a background for folks of like what you see on the apps, the air, how far off the ground you are, how far you've flown away, that you're over a red area, which the Department of Corrections is marked as a no-fly zone.
Representative Provenza, I'm like 50-50 on wanting to know why you're flying your drone near the Department of Corrections red zone.
I'm not flying my drone near the Department of Corrections. However, in the town that I do live in, Because Laramie is small, you get a notification that you can't fly in town in most places because there is a detention center there. So it's, prompt, like telling you, get out of here, if you try to fly in town. There's also an airport near Laramie or in city limits, and that's the other indicator. So typically, if you take it out to public land, as long as it's not a wilderness area, or a national park, you can't fly them there. You will not get the flying dinghy things at your face.
I'm also about 50% surprised that the federal government didn't figure out that this was a problem. But then I'm 50% convinced that I'm not that worried that they didn't figure it out, because I'm not that surprised. Yeah. Director Shannon.
Mr. Chairman, Representative Provenza, I am aware of mapping, but it's mostly for aircraft. For the outliners of where not to fly, it's defined by aircraft.
Representative Rodriguez Williams.
Thank you, Mr. Chairman. Thank you, Mr. Shannon.
Yes,
I'm just curious, does the Department of Corrections currently have policies in place that prohibit your employees from using drones on site as well?
Mr. Chairman, Representative Rodriguez Williams, yes, we do, ma'am.
And a follow-up? Thank you. My second question is in the event that a crime has occurred near the prison or on the prison, and there was a drone being used, is there statutes in place or policies in place with the Department of Corrections that allow the drone footage to be admissible as evidence during the investigation of a crime?
Director Shannon.
Mr. Representative Rodriguez Williams, there is not. That's made an assumption that would be turned over. Any material that would be in the alleged attempt of a crime would be turned over. There is policy defining that for preservation of evidence.
Director Shannon, on the notion of trespass generally, do you believe that we would need to craft specific language around state facilities or around correctional facilities, or if we were to pass something like that, section 159 out of the restatement of torts that just generally tells us what trespass is with an aircraft, is that sufficient enough, do you believe, for your protections?
Mr. Chairman, I believe it would be, and the reason for my statement is, though I would ask that be defined through correctional facilities, I don't believe that would deter people's behaviors.
That we specifically call out correctional facilities, yeah.
Yes, sir.
Okay. Representative Craigo.
Thank you, Mr. Chairman. So my question, and this is kind of a overall question, and it's going to be, this is my problem with enforcing some of these, is how do we catch the operator? I mean, we're now seeing drones that have 5-10 mile range. I mean, they can be in a different town and fly it. I mean, not necessarily in all your facilities, but some of them, they could be in a different town, fly it to your facility. We wouldn't be able to catch them, can't track them back. How do we actually catch the person committing the crime?
Mr. Chairman, Representative Craigo.
Director Shannon.
I'm sorry, Mr. Chairman.
Go
Mr.
ahead.
Chairman, Representative Craigo. I don't have the answer to that. I certainly would like to have some authority to stop that drone, especially if there's a weapon or narcotics attached to it.
Representative Craigo, now we are back to shooting the drone.
And I am thankful for that. Thank you, Mr. Chairman.
Any other questions for Director Shannon? So then let's elaborate on that, Director Shannon. So do you have in mind what that authority to stop the drone would look like in the statute?
Mr. Chairman, not at this time. I do not.
Okay. And then you said I think you referenced conversations at a national level with other correctional directors? And is there something that other states do provide in terms of an authority for a facility to stop a drone?
Mr. Chairman, states such as Alabama, there's different states that actually take action on stopping the drone from anything from trying to utilize other drones to discharging a weapon, things of those natures. Gotta be cautious about that in a correctional setting.
Right.
But as of right now, there's no federal oversight on drones to stop inside the institutions, and the correctional agencies across the state have tried for several years now to get that pushed on with the change of administration, and they took a new run at it, and it is moving forward, but very slowly.
As much as I like the idea of shooting drones, I actually like the idea of a drone battle more.
Well,
I think we should authorize that.
Well, I don't condone that, Mr. Chairman. It's really situational depending on if it's an open yard, things of that nature, the level of the institution. Some of our minimum facilities, we've tracked and, tobacco use, things of that nature that's being dropped off with the drone.
Representative Rodriguez Williams.
Thank you, Mr. Chairman. Director Shannon, so breach of a correctional institution or an attempted breach is a major security issue and safety issue. How do you view a breach of a drone compared to the breach of a human or somebody coming in with some sort of armored car, I don't know, anything like that's attempting to get into your correctional institution? I mean, do you view it as the same potential threat? And in a perfect world, what would you like to be able to do about it from a security setting?
Director.
Mr. Chairman, Representative Rodriguez Williams, I would consider all those threats similar. The issue at hand is the free space of flight. And, but as far as from my perspective, I consider it a threat. We could have individual just curious flying their drone, and we could have individuals that are dropping weapons, dropping drugs, things of that nature. I mean, there's many examples throughout the nation where that's taken place. So I would consider those equal threats. The concern and what's open for discussion is the free space of flying. So an individual who's breaching a perimeter fence, over the fence is much different than a person at 200 feet is the way I think the public views it. But as far as my perspective, I consider it a threat. I can't have an alternative to it, not to consider it, or someone will get injured.
Senator Cole.
Thank you, Mr. Co-Chair. Director, specifically in 2023, they'll be required to have identifiers on the unmanned aircraft to find out, at least to that level, who is registered to that aircraft. We're not there yet, but I think that'll help immensely. And there are there are current statutes in other states that prohibit the flight of drones around a penal institution. So I think that could probably be easily worked into the state of Wyoming, and how you deal with it. I think we can talk about that, what you're allowed to do. I'd like to call it the skeet shooting bill, and you can take them down on top of an institution such as yours. And I'm a little confused though on why local law enforcement cannot do something about, say, a drug drop, because I don't see what a drone is different than someone throwing something over the fence, right? They're just using another way to get there. So I think law enforcement can do something about that, whether they want to or not. Of course, that's up to that authority having jurisdiction, but I think they can enforce it. It doesn't take away the problem with drones, though. I do agree with you. There needs to be something done. And thank you.
Director.
Mr. Chairman, Senator Kolb, I absolutely agree with you on that. Law enforcement's never been hesitant not to assist us. I want to be clear on that. Examples, and I certainly don't want to advertise, but in minimum facilities where tobacco is being dropped, and then we actually video it, it's pretty difficult. I mean, I can provide the evidence to law enforcement, but until we can track that owner of that drone. I mean, we either take action there, which I secure the area at this time. I chose not to do that. If I thought someone was in immediate danger, I would. Beyond that, to identify that owner is pretty difficult for law enforcement.
Committee? Anything else for Director Shannon? All right. Anything else, Director?
No, Mr. Chairman. Thank you, committee members.
Thank you. Emily, who else do we have online? Do we know who they're with? Are they both with Game and Fish? Richard is? All right, go ahead and let Richard in. Welcome, Mr. King.
Good morning. Can you hear me okay?
We can, yes.
Thanks. I apologize. I'm calling from the cab of my truck on the road. So I just spoke with Director Nesvik and he asked that I jump in here and provide any answers to any questions you might have regarding drones, use of drones in relation to wildlife. So I stand for any questions that you might have.
Thank you, Mr. King. My questions were on, and correct me if any of these assumptions are wrong, but it's my understanding that we have two statutes that maybe speak to this in Wyoming, and we define or prohibit the use of aircraft in hunting. The question we may wrestle with is whether our understanding is that aircraft is not defined. So whether it includes a drone or not is a question. And so my question for you is how is that presently enforced by Game and Fish?
Yes, Representative Olson, I apologize that my connection went out for just a minute, but if I understand your question correctly, we do have a statute 233306A, which prohibits the use of aircraft to harass, pursue, hunt, shoot, or kill any Wyoming wildlife except predatory animals by or from the use of any aircraft. And within our Game and Fish Commission regulations, we define aircraft to include drones. And so we have had a few instances where people have used drones to spot wildlife, or more common occurrence. I wouldn't say common, but the situation that comes to mind most often is where we have had people use drones to capture aerial images of wildlife, where they're actually chasing those wildlife with the drone and recording images. And we have pursued some of those in terms of harassment of wildlife.
So, Mr. King, do you feel that your rules and regulations in defining a drone within the statutory definition of aircraft is sufficient for the Game and Fish to carry out its objectives with drones and hunting?
Yes, sir. I believe they are. We have had, this has been an issue for the Game and Fish for quite a few years. And so we have spent quite a bit of time reviewing the regulation and the statute, and we feel like it's adequate for our needs to protect wildlife.
Awesome. Representative Wanser.
Thanks, Mr. Chairman. My question's on burden of proof. So if somebody is flying a drone and you believe it's for harassment of wildlife, and they say, actually, I'm looking for coyotes, what have you had that situation? It seems interesting to me that that's a plausible defense to say they're just hunting for predatory animals, skunks, raccoons, feral cats. Have you had that issue where someone's claimed that they're using it just for predators? And do you foresee any reason that we should need to fix the law to not allow any type of drone usage for wildlife surveillance?
Or, yeah, Mr. King, I'll just pile onto that a little bit, or someone who is just photographing or filming a herd of elk for its beauty.
Yes, so Representative Zwanitzer, to your question, predatory animals are exempt from our use of aircraft statute. And I can't think of any specific instances where somebody's tried to use that as a defense. As in all cases, we have to establish probable cause and determine what their actions are. And the same goes to collecting video footage of wildlife. We look at the totality of the circumstances and need to make a determination as to whether there's an attempt to take or harassment actually occurring versus just video footage. And so each is a case-by-case investigation and determination. And I think in general, our statute and regulation is sufficient for our needs. We really haven't run into any issues in terms of enforcement or prosecution as a result of inadequacy in the regulation or the statute.
Mr. King, Senator Cost was curious earlier on, I think you were asking about drone use and spotting sheds. Is that permissible under the statutes and your regulations?
Yeah, Mr. Chairman, that spotting sheds would not be prohibited under the current statute and regulation. The statute's just specific to wildlife.
Okay, yeah, it sounds like it just comes back to that gray area where it all depends on the facts and your burden of proof as to whether there were animals in the area when they were searching for sheds or what have you.
Mr. Chairman, that's correct. Yes.
Okay, Representative Washit? Nope. You, okay. I read his question. Any other questions for Game and Fish or Mr. King? Mr. King, you have anything else you think you want us to know?
Mr. Chairman, no thanks, but I will stand by. I'll stay on in case there are any other questions that come up. I appreciate the opportunity to jump in here on short notice. Thank you.
Actually, I have one more for you, Representative Larson.
Mr. Chairman, and I don't know, maybe we already discussed this and I missed it. Mr. King, do you have issues where people are driving on private property and there's trespass, but cannot do anything about that because they're not hunting, or have a way around that? Or if you can comment.
Mr. King.
Mr. Chairman, Representative Larson. So our trespass statute is specific to hunting and fishing, but it also includes the collection of shed antlers. So if we have a call from a landowner about a trespassing complaint, our first step is to determine what those individuals are doing. Are they hunting, fishing, collecting shed antlers? If so, if we can prove that, have enough probable cause, then we can proceed to issue a trespassing citation for those instances. And so I think if it falls outside of that, of course, the criminal trespass statute comes into play, and the Game and Fish Department does not have authority to enforce criminal trespass. That's handled by the sheriff's office. So in terms of our statute being sufficient for hunting, fishing, and shed antler collection, it works very well. But again, every case needs to be looked at on a case-by-case basis.
Representative Larson, follow up.
Mr. Chairman, thank you. Did you have a chance to read Representative Crago's proposed bill from last session, and do you have comments on that? Would that help?
Mr. King, House Bill 103.
Mr. Chairman, Representative Larson, I apologize. I'm drawing a blank on House Bill 103. So
let's do this. Representative Crago, can you give a quick your summary of that bill?
Thank you, Mr. Chairman. Actually, I was going to apologize to Mr. King. So I believe today's Wyoming Wildlife Task Force as well. They're meeting today and tomorrow, same time as our meetings. And I had discussions with the director previous, and I wasn't going to bother him. I figured once we actually get some language put together, we could run it by the agency to get their input on that. But I knew they were tied up today and tomorrow with other stuff. But I did talk to him. Mr. King, my bill, House Bill 103, essentially what it said, it clarified, because it's my understanding and dealing with local game and fish agents, that some different local agents around the state interpret the statute differently. Some interpret it to say that you have to be actively hunting, shed hunting, fishing, et cetera, on the private property to be written a ticket under the game and fish statute. There are some places in the state where they actually prosecute it, even if you're just driving through private property to go hunt, fish, shed hunt, et cetera. And so I was trying to clean up that particular provision within the law so that it's equally applied throughout the state of Wyoming. And so that's the bill. And like I said, I had talked to the director back before session, during session, et cetera. And hopefully as we move forward, we'll continue that conversation with game and fish.
All right, Mr. King, you're saved from testifying on the hypothetical bill.
Thank you.
Yes, Representative Zwanitzer.
Thanks. Just a short question. Do you know roughly how many trespass citations are issued by Game and Fish in a year? I assume the counties don't really track that, and no one probably outside of your agency tracks a total number. Do you have those numbers?
Mr. King?
Mr. Chairman, Representative Swanitzer, I do have those numbers. If you give me just a few minutes, I'll pull those up and I can email them to you.
That's perfect. Anything else for Mr. King or Game and Fish? Sounds like we'll talk some more later. Thank you, Mr. King. Really appreciate you zooming in while you have other things to do and kind of taking that cold call for us. We really do appreciate that.
Absolutely. Thank you.
All right. Anyone in the room wishing to testify on these topics?
Good morning, Mr. Chairman, members of the committee. My name is Elizabeth Arano. I'm here as a Lander citizen and as a UW student in the remote sensing graduate program. And as part of that program, I'm studying for my remote pilot license, aka drone pilot license. I have some prepared testimony I'd like to read, but I'd also have a couple tidbits that I think may be helpful per earlier conversations. The first being regarding the correctional facilities. You can see in the material provided by the LSO that there are several states that specifically have statutes prohibiting flying over those with UAVs. Other things just to keep in mind, we are focusing a lot on the photography, which is a very common use of UAVs. UAVs come with a platform, aka the drone, but they also have different sensors that can be put on them. And those are not just the typical camera that we may be thinking of as we think of photographs, et cetera. Those, depending on price point, sensors that can be added can sense things all across the electromagnetic spectrum. So they can be heat sensing, they can look at different light reflectance to detect different vegetation, different minerals, et cetera. And I think that's important to keep in mind as you consider this, that it's not specific, it's not exclusively photographs that you may be in dealing with. So we have a problem. We have human, wildlife, and livestock harassment by UAVs in our state. I too have been incensed when followed by UAVs while out recreating in areas like Sinks Canyon. This harassment is most likely by hobbyists or recreationists, those who do not need a remote pilot license to operate. And they're unfortunately exempt from the bulk of regulation and training requirements by the FAA under Title 14 of the Code of Federal Regulations, Part 107. A possible solution, I suggest laws addressing the specific behaviors, the privacy violations, and the harassment of wildlife and livestock, not addressing the airspace as the best path forward. As you saw in the meeting material, other states do not attempt to regulate the airspace, which is seen as federal. Indeed, a recent exemption granted by the FAA to the UAV visual line of sight rules allows for flight under tree canopy. The FAA regulates airspace very close to the ground. To both accomplish our goals and avoid wasteful litigation, I suggest creating two categories of regulation. First, regarding privacy. Second, regarding animals and recreation. Regarding privacy, I support legislation similar to those of South Dakota, Alaska, and 9 other states, which prohibit voyeurism by UAV, an invasion of privacy. I would ask that you also consider the prohibition of use of UAVs for hunting and clarify that in statute, though that may not be needed, as we just heard recently from Game and Fish. Please also include molesting or locating game animals, game birds at fur-bearing areas and harassing livestock in our statute. You'll see that in the statutes from several other states, though they do not include livestock. I think that's important for us. Other statutes also include interfering or harassing a person legally engaged in recreation. They specify hunting and anglers as folks who should not be harassed by UAV when recreating. I suggest that we expand that to also include folks who are climbing, biking, hiking, swimming, or otherwise legally recreating on public or private lands. With our expanding recreation economy, it's important that these protections include all recreationalists. A fiscal thought. As you heard from the LSO, tools for identifying UAV operators breaking the rules or otherwise misbehaving may be coming with the FAA's remote ID rule, which comes into effect in September 2023. The FAA created the remote ID rule to protect airspace safety and national security by requiring all drones from 0.55 to 55 pounds in the US to broadcast a digital license plate that is accessible in near real time to the FAA, national security agencies, law enforcement entities, and other government officials. When the RID capabilities go live, law enforcement will be able to access drones identifying information. They will also be able to correlate the information with other personally identifiable pilot data should it be available in the FAA databases. In other words, the rule enables law enforcement to locate pilots violating privacy rules or harassing wildlife. The DC District Court is currently deciding race day quads versus FAA, a lawsuit over this rule. If the rule stands, our law enforcement agencies, including Game and Fish, will need funding for easy access to equipment to monitor these frequencies. Thank you for the opportunity to speak. I'll stand for questions.
Committee questions? Please.
Thank you, Mr. Co-Chairman. Would you be willing to provide your statement in written format for the committee to consider and LSO perhaps?
I would be happy to email it to you this evening.
Thanks.
With the FFA moving forward on rules regarding digital licenses for drones, is it necessary or would it just be duplicative or actually completely unnecessary for the state of Wyoming to do anything with that?
My legal background is perhaps weaker, but I do not know that it would be possible if this lawsuit is overturned by the DC District Court if the rule is overturned by the DC District Court for our state to still have that identifying information. Right now, all that we're just awaiting the decision. The case has been argued, so that should be imminent, potentially in the next couple months that we hear that decision. And right now, it's a privacy issue for the drone operators as well, as we're trying to balance that with the privacy issues and harassment issues that we see. I would suggest that it is less likely folks who have gone through the pretty intensive testing requirements to get even the entry-level remote pilot's license. Those are not likely the folks that are out there doing the harassment. It's likely folks who are exempt in this hobbyist and recreationalist category. I do think our hands are likely somewhat tied in adding restrictions just for that category, but that could be something for the LSO to investigate if we can have restrictions or training requirements for hobbyists and recreationists who are exempt from the Title 14 CFR Part 107.
I guess I just don't understand the legal nuance. I have to register my boat, my camper, my car, all of that with my county. And all of that, while not digitally just posted on a website, is open to a public records request, I would assume.
I would assume that the UAVs that are of a certain weight and do have to be registered, which includes all commercial and then some weight-based, I assume that is public record, but I have not pursued finding that out myself.
Senator Kolb.
Thank you, Mr. Co-Chairman. I just had I guess, a clarification question on what you consider personal harassment when you're recreating. Just how would you define that?
I think that's a great question. My personal piece is when I am getting buzzed from multiple directions by a low flying UAV, that it's interfering with the acoustic part of the experience, as well as my sense of privacy, even though I may be on public land. It is a sense, not necessarily a right on that land.
That help, Senator Kolb?
Well, I guess a follow-up now. Thank you,
Yeah.
Mr. Co-Chairman.
Go ahead.
So it sounds like you may say it's a deal where it would be, you're aware of the UAV, say audibly, doing something around you, because I think sometimes we get into an issue where it's about being viewed. And frankly, with satellite technology, I mean, that is a separate issue. But I think to expound on that about being aware, say, and you would go with wildlife, the wildlife being aware of a UAV vehicle hovering around, you would consider that to be a problem, as it would be a personal issue with you when you did recreate or do recreate.
Representative Olson, Senator Kolb, I had not considered that, but that could be an interesting guideline that doesn't get into restriction of airspace based on height. However, you should be aware that there are multiple types of drone platforms. And so it's the rotor drones that create that sort of buzzing noise we may be all familiar with. And those are most common. And those are far and away what is overwhelmingly sold at Walmart, et cetera, where a lot of the hobbyists will procure their drones. There are fixed wing drones, take off and land differently. They operate slightly differently. And so I do think that would accomplish a lot of the goals, but do want you to be aware that not all drones are rotor drones.
All right. Thank you very much for your testimony, and thank you for sharing that paper with us as well.
Thank you.
Anyone else in the room wishing to testify on drones and hunting? How many folks do we have remaining in the digital world?
Mr. Chairman, we have Chad Parsons and Tim Cotton right now who have raised their hands.
Okay. Welcome.
Thank you, Mr. Chairman. Jim McGagnon with the Wyoming Stockbrokers Association. And rather than be repetitive, I would generally endorse the comments that were provided earlier by my colleague with the Wyoming Farm Bureau Federation. On both of these issues, we particularly see the need for legislation along the lines of that was offered by Representative Craigo, because we're seeing the inconsistencies sometimes on the same land that might just happen to be under the jurisdiction of a different personnel within the Game and Fish Department. So we would encourage that. Just one thought with regards to drones, and I think there's a need for some guidelines there. Just to make you aware, we're seeing increasing use of drones by ranchers as a convenient tool to go out, particularly in rugged terrain, and check on livestock. And so we have to be careful as we move forward there that we're not doing something that would preclude that very efficient use of and positive use of a drone. And finally, Mr. Chairman, if it's appropriate, I'd like to just mention a couple of minor items with regards to Title VI that perhaps the committee would include in your consideration as you move forward. One has to do with just the fines that are provided for. Title VI provides for a fine of maximum $750. The other various laws relating to trespass that were cited in the LSO memorandum all have a $1,000 fine. Would see some value in creating some consistency there by increasing that one to $1,000. The other issue that was mentioned briefly by Mr. Odekoven, under Title VI, criminal violation has to be either prior notice or a sign indicating no trespassing. That was very appropriate at the time that was put into statute. Today, things have changed significantly. We have far better mapping than we had then. We have the use of GPS systems so that there are many ways to determine whether one is on private land or on public land, short of what's in there. So I think some modifications of Title VI there to indicate that some responsibility of the party to use reasonable tools. We recognize they're not perfect. So there needs to be some flexibility in there, but certainly beyond just notice or posting. And one final thing I would mention with regard to posting, and I believe this might have been even in a bill that was being discussed. I'm not sure if it was ever filed in the last session of the legislature. Several states that I'm aware of provide, for example, that painting the tops of fence posts a certain color can constitute notice that it's private land, and doesn't allow for the type of vandalism that we often experience with the use of actual signs. So posts, in a lot of cases in Wyoming, our private lands aren't necessarily fenced. So the use of rocks or something and providing in statute the distance of placement that posts or rocks would have to have in order to serve as adequate notice would be in another area that with some minor change to the statute, I believe we could make it just workable for all parties. With that, Mr. Chairman, I encourage your work here and happy to work with you and would welcome any questions.
Yeah, Jim. So before the last session, there was a group of students in Cheyenne who were talking to me about bills that had been filed, and they came across the one-page bill on painting fence posts. And they said, this is like the simplest, easiest, straightforward bill. And as it turns out, it's far from it. I guess it's pretty controversial.
It was, Mr. Chairman. I understand that. Our only concern with it was that when it says fence posts, that's adapted from areas that typically all the private lands tend to be fenced. That's certainly not true in a lot of areas of Wyoming, and that's why we were looking to broaden that a little bit so that something other than a true fence post could be a true indicator of a boundary private land.
Got you. Question, Senator Cost.
Thank you, Mr. Chairman. And Director, that bill was presented by Representative Flitner and myself. And due to the nature of some of the controversies, it was thought that we needed to have more discussion on it before we went through with it. So it was pulled for this kind of debate so we could learn more before we presented it. So it would be a better bill. So.
Thank you, Senator.
Welcome.
Mr. Chairman, members of the committee, I'm Jess Johnson. I'm with the Wyoming Wildlife Federation. And I'll keep this brief. I just kind of wanted to commend you and touch on the subjects of keeping up with technology as fast as it's changing, as in regards to hunting and the sort of fair chase ethic that happens behind it. I wanted to sort of draw a note to in 2019, there was a hunting methods bill that came out that was sort of broadly offering authority to the Wyoming Game and Fish Commission to regulate this quickly and fast, not having to do it as legislative sort of sessions ebb and flow. That bill did pass, but it passed with some pretty severe sideboards where it was only looking at real-time camera imaging, the sale of GPS points, and I'm forgetting the third one, but it was not drones. But drones are regulated under them already. They were able to do that. The one thing I would draw the sort of thought to is that as we are seeing shed antler collection just go through the roof as far as like the desire to sell these antlers, I imagine we are going to see more and more sort of technology being used to find these. And I would just say that I think it is a forward-looking thing to add that to the list of stuff we are concerned about. We are able to put seasons on shed antler collection as far as the Wyoming Game and Fish Department. They have that authority. I think everything west of I-90 or south of I-90, west of I-25, I think is the where they have it. But it's now that we've fixed the wildlife harassment, now we're working on the sort of damage to land that happens with everybody going out in early spring. As we all know, it's very nice and wet in Wyoming right now. And so you're looking at all of this stuff. I think as this comes down the pipe, shed hunting is going to be a mega issue that we're going to just have to figure out how to deal with and figure out how we do it well, and well for wildlife, well for the recreators, and well for the state of Wyoming. So I would just say sort of keep that in your mind as we're looking at the drone stuff, because right now I think the language that is currently used in regulation for drones is to spot, locate, or aid in the taking of wildlife. So it doesn't really hit anything that would not be connected to the wildlife. So thank you, and I'll stand for any questions.
Question, Senator Kolb.
Thank you, Mr. Co-Chairman. In my neck of the woods, Southwest Wyoming, I've been told by people who are involved with landowners, and not so much the people picking up sheds, but they do geocaching of all those sheds. And the night before you're allowed to pick up sheds, there's a slew of folks out there collecting the antlers for the next morning when it's legal to collect them. Have you heard about that? And what's your opinion on that? And look forward to hearing that. Thank you, Mr. Chairman.
You know, as far as my opinion on that, I'm a little bamboozled by the desire to just hoard sheds and sell them. And it's one of the only untaxed resources you can ever pull off of public lands and sell in the state. You can't even do that with rocks off of BLM land. But I have heard of that. I've seen it. I think it is probably very much an issue. And it, you know, I've heard stories from game wardens, and mind you, this is anecdotal, but stories from game wardens of people using drones to spot sheds and sneaking in on private land, not getting caught because they can figure out where it's at and coming out, but they can't get caught. They know this is happening, but they're not being able to catch it in the act. So there is like some issues with this. And you know, personally, I'm a person who spends my spring looking for bears and turkeys, not sheds. So. I would have one more addition if you're, I just sort of
Sure.
To the testimony a little earlier, when you're looking at how you're regulating drones and drone behavior, I think it was the woman before me that said regulating the behavior, looking at the ethics behind that is probably a much better use of time than just blatant airspace.
Great. Thank you for your testimony.
Thank you.
Commissioner.
Good morning, Mr. Co-Chair. Bill Novotny with the Wyoming Outfitters and Guides Association, and I do apologize. Most of our membership is in Casper today with the Wyoming Wildlife Task Force as they work through some pretty critical issues. But they asked that I be here to share our support for the bill offered by Representative Crego during the last session, in the hopes that this committee will move it forward in some fashion as actually as a committee bill, because we believe this is a critical issue. We are hearing from folks across the state in increased number of fences being cut and gates being left open this spring. We assume it's probably folks going after sheds. And certainly we want to work to protect the resource, whether it's wildlife in their winter ranges or just making sure that people are being ethical in their behavior, and certainly when they cross private land. And we echo the sentiments shared by Mr. McGagnon with the Wyoming Stock Growers Association and the need for this to be addressed. So with that, Mr. Chair, I would stand for any questions.
Committee. How'd you draw the short straw, Mr. Novotny?
Mr. Co-Chair, who doesn't like to visit Lander? So I don't think it was a short straw at all.
Great answer. But because it's committee number one, Judiciary was what you meant to say.
Absolutely, Mr. Chairman. And I'm sure that we'll have an opportunity when you do move something forward, whether it's dealing with hunting by drone or this trespass bill, to be before you again. So hopefully I'll bring a bunch of men in camouflage to share their thoughts.
We appreciate that.
Thank you, Mr. Chair.
Let's go ahead and let some of our virtual people in. Mr. Cotton.
Am I on? Thank you.
Yes.
My name is Tim Cotton, and I am I live in Converse County, but I work in Casper. And I guess I'm going to ask for a little indulgence. I'm going to address the H Bill 103 introduced by Mr. Crago, and then briefly the corner crossing. You know, I guess I would just.
Mr. Cotton, sorry to interrupt you, but let's go ahead and address 103. Let's save any comments you have on corner crossing. We really haven't been talking about it, and we have about, I don't know, 5 minutes left on this topic as a whole. So
I get that, but my schedule.
We may not even, well, we may not even talk, Mr. Cotton, we may not even talk about it. So.
Okay, well.
It's not a topic that we're taking up, even though it appeared in the memorandum.
Okay.
So I'm trying to save you and everyone a little bit of time.
Well, I will just preface that by saying that I am an absolute advocate for public access to public lands. And hopefully when this topic does come around, that this committee will understand that. So as far as the, you know, I'm an attorney, and the bulk of my practice is criminal defense. So I guess that in my opinion, in my experience, oftentimes, you know, giving more law enforcement authority to game and fish and hoping that they would use their discretion, that perhaps oftentimes they are poor custodians of the discretionary role. And so what I see here is a problem when you're trying to make this game and fish statute a criminal statute where they can enforce somebody simply traveling through with no notice, with no intent, and I just fear that if we do this, then we're going to open the floodgates to game and fish abusing that authority and stopping more people for other means other than just driving through a road. If this committee goes down that path, then I would urge some sort of language on there requiring notice, requiring intent to travel through for the purpose of hunting and fishing. You know, I just worry that with it being so open-ended that we're going to end up with a mess. I do know that there are plenty of places in Wyoming, and I have litigated some of them, where there are commonly used roads that cross small sections of land, like out here on Poison Spider. There's a couple 100-yard section that's not fenced, that runs through some power lines that hunters use to cut across from the road over to public lands that some people use to hunt, other people use to run their dogs, that, you know, game and fish parks on that. And that's, you know, kind of what they do. I think if we have this modified, as Mr. Crago says, then we'll be opening up a whole bag of worms. Another thing is I understand that there is a difference in the enforcement in different counties, as Mr. Crago laments. But the reason for that is because county sheriffs are answerable to their constituents. So, and I think a lot of the enforcement on, especially these type of things, are reflected by that. But then if you change this to have an unaccountable, unelected game and fish department enforcing it, that I think that we'll end up with problems that way as well. So those are my thoughts on that. Mainly, I came on to talk about the corner crossing and got sidetracked on this, so I apologize.
Questions for Mr. Cotton? Yes, Senator French.
I'm curious, sir, Mr. Chairman, I'm curious why you feel the public has the right to cross private property. Don't they have the responsibility to know where they're at? There's modern GPS, there's all kinds of things that they can determine within feet of where they're at. Why do you think they have the right to cross my private property to get to some other land? Thank you.
Well, I mean, obviously, was that directed at me, sir?
Yeah, I was just calling on you.
Well, I think certainly we understand that there is a right to private privacy, and I wholly embrace that. But we all also understand, especially in the wilderness, that there are easements, whether there are intentionally there or implied easements, that people have used these paths for a long time. They've used roads and paths through private property, and it's become the norm. If we have this change to where there's no intent to violate a game and fish statute, then we've made the game and fish officers the equivalent of a law enforcement officer, like a sheriff, with no oversight. I'm not advocating that people should trespass on private land, but it's always the absurdities that come to the rule, like the one I told you out on Poison Spider. When that went to trial, and I asked the game and fish, had you even contacted the landowner to find out whether they cared? No, they hadn't. They had no idea whether or not the landowner, who was owned out of California, even cared whether or not the people used the road, and it's actually like a telephone pole maintenance road, to access, across this 200-yard piece of property, to access public land. But they were enforcing these laws without even contacting the landowners. That is the problem. And there's another spot over, it's off of 2026 out of Glen Rock, where the substantial quantities of public land are split by the interstate. There's a road that's well groomed, well traveled, that goes underneath the interstate to access that. But the small piece of land underneath the interstate, the underpass, was purchased first by an outfitter, and now it's owned by a ranch, and they've gated it off. So you can't drive from one side of the interstate to the next side of the interstate to access the public land. Instead, you got to go way around through some pretty gnarly roads to get over there. That's the absurdity that I think controls the conversation. If you think that I have a right to go on your property, I don't think that. But I do think that we have a right to access public land. I hope that answers your question.
Senator?
Follow up, Mr. Chairman. But where does this end? I get where you're coming from. I truly do. But where does this end? I mean, today it's you fight for that 200 feet that's in question. Tomorrow is it 400 feet? The next year, 1,000 feet. The next year, half a mile. Because gosh, there's 10,000 acres of public land, and there's that one ranch or farm that stands in my way of getting there. How far do we take this?
Well, I think there needs to be an implied easement to public access to public land if that landowner is receiving any benefit whatsoever from the use of that. So for example, if they're leasing it, if they're being able to treat it like their own, if they are getting revenues from hunting, then there needs to be an implied easement for the public to use that land. Otherwise, it's absurd to the degree that you have landowners who have landlocked public lands of prime resources that they're using as their own, benefiting as their own, to the detriment of those folks who pay taxes to support this land. And I think we'll have to go there at some point, but there needs to be reasonable access, public access to public land. As far as this bill, there's already a means to do that. If the landowner sees somebody crossing their land and they don't like it, they can get the tag number, they can call the sheriff can come out and investigate. To make game and fish now more of a sheriff in this role of enforcing things that have nothing to do with hunting and fishing is a mistake, in my opinion. So I think the statute should stay as it stands. So.
Mr. Cotton, I'm a little hazy on my foreign bovines, but is that a brown yak or a Highland cow?
It's a Highland cow, sir.
Okay, excellent. That was my first guess, even though I read it second.
And he doesn't like
Right,
drones
either-
either.
I would believe that. Any other questions for Mr. Cotton? All right, thank you so much, Mr. Cotton.
Thank you.
Emily? Okay, and Chad is signed up to testify on corner crossings, but would like to testify on drones or hunting? Okay, well, let's let him in.
Thank you all for allowing me to speak. I thought my comments on drones were going to be pretty simple, but I guess with everything else, once there's technology and we find 5 good things to do with it, 10 other bad things somehow get sorted out.
Hey, Chad, when you came into the world, you through the virtual world, sorry, that's a different conversation. Chad, when you came in through the virtual world, there was a bit of a limbo state, so we didn't hear you introduce yourself. If you could just do that for the record, that'd be great.
So I'm Chad Parsons. I am a landowner. I also own and operate a nonprofit here in Wyoming that provides hunting, fishing opportunities, outdoor adventures for veterans called Veterans Help Foundation of Wyoming. And what, bringing up the drone topic, we've been toying with the idea of using those drones to enhance the experience of our veterans for their hunts, their fishing opportunities, things like that. I thought that was pretty clear cut as far as harassment of wildlife for the use of drones. I thought it was pretty clear cut on, fair chase. I thought that maybe that those drones could actually be looped into the same verbiage as the use of cellular trail cameras. Anything that would help take game by the use of technology. But hearing some of this testimony that's already been presented, I see that there's a huge amount of research and a huge amount of work that needs to be done to clarify that. As far as using drones and trespass, the only caution that I will put out that I see as a sportsman is airspace. That's one of the big topics that keeps coming up, either with drones or with the use of airspace as a means of trespass. I think airspace is something that we need to leave completely out of general trespass if we are going to use that for drones. The reason being is once something gets clarified to a point, it seems to overshadow anything else and used in other areas for prosecution. I also, as far as general trespass, believe that for someone to blatantly walk across somebody's private property, and I mean contact with that property, to access public lands without permission is criminal trespass. It's pretty simple. Trespass to hunt could also be touched there, but they are completely 2 different things. And I don't believe that we should make that something as far as criminal trespass goes that Game and Fish should handle. And trespass to hunt needs to be handled as a Game and Fish only matter. As far as going through private lands to access public property, it is my understanding, as long as it is a county or state maintained roadway, that you can use it. If it's someone's private drive, again, blatant trespass. So I'm trying to be as brief as possible on both subjects. If somebody has a drone flying over somebody's property to hover, look at specific items on that, their cattle, their other livestock, their house, their barn, I feel like there should be a way to prosecute that. That's invasion of privacy. But as far as to use a drone for the use of collecting pictures of scenery, things like that, that would be a completely different matter. So again, like I said, everything that I had in place in my mind is very simple statements. From what I've heard so far are no longer simple. And I truly do not want anything to do with the decisions that you're up against in that matter. Those are really the only things that I have to say. And I'm open for questions.
Committee, any questions? All right. Well, we do appreciate you joining us and providing us with your thoughts.
Thank you.
Anyone else in the room wishing to testify on this, on these topics, drones and hunting? One more in the virtual world, okay.
Hey, Mr. Chairman, committee, good morning. My name is Nick Dobrich. I'm in Du Bois with Theodore Roosevelt Conservation Partnership. We're a sportsman's conservation org. I just want to say thanks for addressing this issue, and I have a comment related to Crago's bill, Representative Crago's bill. One of the issues, and a lot of people have touched on this, is not the deliberate, people deliberately crossing private land. Of course, we all know that's not right for hunting or for whatever reason. That's just not right. The one issue though is, with everybody having access with smartphones to land ownership data, like with apps on X and such, what's not provided is public easements. These could be held at the federal level, county, state level. And this is being fixed right now at for federal easements. So when the Forest Service owns an easement across private land, being it a road or a trail, these are usually stuffed historically as paper records, typically buried in someone's office and file cabinet. And it creates a lot of confusion for not only the public, but some private landowners may or may not know that that easement actually exists. So the legislation that we worked on at the federal level called MAPLAN just passed Congress, was just signed into law a couple of weeks ago. It had full support of our Wyoming delegation. And it basically requires federal agencies, including the BLM and the Forest Service, to digitize all these easement records and make them easily available to the public. The same problem exists with state-held easements. So here, where I live up in Du Bois, Game and Fish holds a bunch of fishing easements on the Wind River that you pull up at the parking lot to go fishing. The maps are super old and kind of confusing, and you're fishing in someone's backyard essentially, and you're wondering if you're staying in bounds or not, and you're wondering if you're following basically the law. You don't want to be trespassing, but you're not really sure where the easement starts or ends. And this isn't just an isolated case here up on the Wind. This is statewide for the easements that are held, not only Game and Fish, but state lands and state parks. So I guess as you consider the trespass issue more broadly, this is something that I think would be very valuable to address with the state agencies, potentially with legislation. Thanks for the opportunity to provide input, and I'll stand for any questions.
Committee questions. All right, we do appreciate your input. Thank you for that. All right, anyone else wishing to testify on these topics? No. All right, I will close public comment. Committee, what are your thoughts? Would you like a motion for a bill? Senator Cole?
Thank you, Mr. Co-Chairman. I would make a motion for a bill to continue a bill draft process for this topic.
Which would you like?
There's a plethora here.
Yep. Representative Crago's House Bill 103.
Right, Representative Crago's Bill 103. Does that also, would it include drones?
No.
No.
I'll
start with Representative Crago's Bill 103.
Okay, and Representative Crago has seconded that. And I'm assuming that Representative Crago, that's a good place to start. And then I don't know if you, since coming out of session, if you have things that you think that that would be a better starting place with that bill, but we can work that through LSO if we need to. I just need to know what your thoughts are.
Thank you, Mr. Chairman. So I think it's a fine jumping off point. It was pretty simple, but one of the things that came up after, we put the bill out, published the bill or whatever, was there's some concerns about the language that we used in that actual bill, and we need to clean that up. I mean, in all honesty, the language we ended up using wasn't, that I asked for wasn't great. And so it's not clear. For example, the one like I talked about earlier, for example, if you're floating a river through somebody's, the river runs through somebody's private property, they own land on both sides of the river, is that trespass? No, we need to clean that up. In the way the bill was drafted, it also would. It could also encompass corner crossing. We need to get that out of the language of the bill as well. We need to talk about actually physically entering, stepping on, private property and walking through, driving through, whatever that is on the actual hard surface of the land. And so I think LSO can figure that out. But that's what we would need to do as far as the language, because the language we had used in the original bill was travel through, and it brought up all these questions. And so that's what we need to clean up.
So then I understand the motion to be to exclude that the corner crossing issue and the floating the river issue, so that when we work with LSO between now and having the actual bill draft, we won't start with HB 103 as was. We will start with HB 103 as modified. And I think that would be helpful for the public, so that we don't have, 1,000 people show up to testify on something that we plan on removing from the bill. We ought to just remove it in advance. Do you have thoughts on how to do that, or with LSO? We don't have to know right now. I just want to make sure we're working through it before we post it.
I do. Okay. Yes, Mr. Chairman. And then the other thing that we probably need to talk about is House Bill 103 as drafted included the forfeiture provision. It changed one of the penalties because one of the problems that arises on the trespass to hunt is you travel through somebody's private property, you go collect $5,000 worth of sheds, you're happy to pay a $500 or $1,000 fine to haul those home. And so that was one of the issues that I talked about with the director. We don't have to necessarily get into that today, but I think that's something that's in the bill. So we need to, if we're going to ask LSO to move forward with the draft, we probably want to we haven't really discussed that today. So we may want to talk about that at the next meeting. But as far as the original language, we probably should take that out for now.
Okay. All right, perfect. Then Mr. Fuller, you'll just work on that draft with Representative Craigo between now and the next meeting. All those in favor of that motion to have a bill draft? Oh, that was discussion. We are in discussion. Do you have further discussion, Representative Larson? I absolutely will not prevent you from speaking in this meeting. Oh, okay. Representative Craigo, more discussion.
Mr. Chairman, and I just want to clarify, it was not LSO that used the wrong language. It was language I specifically asked for. In fact, I think they probably told me at some point, that's not going to work. And I said, let's do it anyways. And so just to be clear that was wording that I specifically asked for.
We already assumed that much. Representative Craigo. You're good? Okay. Anybody else? Would you like to vote on that motion?
Yeah.
Okay. All those in favor signify by saying aye.
Aye.
All those opposed? Any other motions? Representative Provenza?
Thank you, Mr. Chairman. I think, it sounds like we need to take out that subsection C of 6-3- both the criminal and civil. So I would ask for LSO to draft legislation to repeal that language that's been deemed unconstitutional.
Moved by Representative Provenza and seconded by Senator Cost. They got that one. Although, any discussion on that motion? No. All those in favor signify by saying aye.
Aye.
All those opposed? Motions for additional bill drafts? Oh, sorry. I always lean this way. I don't know what it is. Go ahead, Vice Chairman.
Thank you, Mr. Chairman. I would ask for a bill draft specific to Mr. Shannon's concerns about drone flights over state prisons. And I believe there are a number of states that already have similar statutes we could use as a model. How about California? Alabama.
Mr.
Whoa, yes, co-chairman.
Thank you, Mr. Co-Chairman. Does Representative Washit, does Alabama have a provision allowing for the seizure or destruction of the drone?
That I'm not aware of.
Mr. Fuller?
Yeah, Mr. Chairman, my question would be along those lines is, a number of states have statutes that simply make it a crime, misdemeanor or felony to fly a drone over a state correctional facility. I think the question for the direction for us would be, would that encompass some sort of attempt to draft language to allow for the seizure or destruction of a drone under those circumstances?
Or drone battles, which we want to make sure are permissible. Representative Oakley.
Thank you, Mr. Chair. In relation to that, I guess I would like to put forward to the committee that we do include language. It's pretty broad, but I had something along the ability to capture or disable the drone by whatever means necessary, something like that. I mean, it's pretty strong, but policy wise, I guess I would put that forward.
Okay, further discussion, co-chairman Nethercott.
Mr. Co-Chair, yeah, going back to, it was kind of the question I was driving at for whether or not that concept should be included in the bill draft, but let's circle back and identify what Mr. Fuller has asked for clarification on, which may or may not be in these states that we're looking to adopt. So let's just take a minute and find those in the memorandum. But one, should it be a felony to fly a drone? And if so, does there need to be an intent element associated with that? I would assume the answer to that would be yes for this committee in order for that to happen. And then what is the difference between a felony or a misdemeanor level associated with that conduct, and which would require some intent elements and any other type of element to think about. So certainly a further discussion from those other states, I think, is warranted. Mr. Fuller.
Yeah, Mr. Chairman, Chairman Nethercott, I would just note for the committee on page 4 of that appendix that was included are at least 2 examples of these offenses. So at the very top of page 4 says Delaware is continued from page 3. It makes it a felony to operate a drone over a correctional facility to deliver prison contraband. Further down that page for Georgia, there's an example of prohibiting drones from delivering or attempting to deliver contraband to a correctional facility and from photographing any place of incarceration without prior permission.
Vice Chairman Washington.
I believe that falls within my motion. I think that clarifies what we're asking LSO to draft.
Okay. Representative Rodriguez Williams.
Thank you, Mr. Chairman. In light of discussion, taking it a further step, I had some notes here to consider 400 feet over. It looks like some of these statutes in other states specify operation of any UAS under 400 feet over any correctional facility, law enforcement facility, state capitol complex, state hospital, or any other critical infrastructure facility. And I'm not sure if infrastructure facility is defined in our state statute, if there's a need for that. I like the idea of making it a felony and the prohibition of using UASs from taking any images, imaging. We talked about heat, sensory a little bit. I think when you look at the security of correctional institutes And if somebody were using a drone to identify a person within an institution that they're trying to catch, that a drone could be used in that sense. So imagery or video. Furthermore, I like the idea of prohibiting using a UAS for transporting any contraband to and from such facilities. Yeah, just my thoughts.
Yeah, we certainly could. I mean, we can certainly, if it's within the motion and the committee mover and second, we're inclined to accept that, or we can have an additional motion on whether we want to expand that beyond correctional facilities to critical infrastructure, which arguably includes pipelines. That will become a fun topic, but we certainly could look at additional, and actually your point is what I was thinking in the very beginning is whether we were going to start with a general addressing generally the law with respect to flying drones in Wyoming, period. Rather than have multiple bills, that's an option too, that if we were going to adopt the restatement as an example, co-chairman, that we could include everything we're talking about in drones in one single bill versus just correctional facilities, capitals, infrastructure. We keep expanding it. We could start there.
Mr. Co-Chairman, no. I do think that this needs to be a separate crime identified explicitly, and then the restatement of torts, remember, is a civil law, which could be adopted as a civil law and could be turned into a criminal law. But I think it's important to distinguish out what has been asked by our Department of Corrections and to keep the element associated with that crime of flying a drone over a correctional facility. The elements associated with that are going to be fundamentally different than the restatement of torts. And so I do think it's prudent to keep it separate. I think it's important to keep it broader than what maybe some of the states that we've identified from doing, and this concern about flying in or flying out contraband, which certainly needs to be part of that, but also the concern over photographing both not only the facility, but the individuals within it for all kinds of security reasons. So that's a second component in there that would add to that felony piece, I think, is what Representative Rodriguez-Williams was going for. Representative Washington, do you consider that friendly?
Well, Co-Chairman Nethercutt, just to clarify, I'm not suggesting that they share the same element. I'm suggesting that you have an omnibus trespassing bill with drones in general, because you may have separate statutes, period. And I'm just proposing that to the committee. We jumped straight into the idea of addressing drones with our correctional facilities. My question is whether you want to address drones and trespassing generally, as well as specifically in that scenario, critical infrastructure, capitals, other government facilities. I mean, all of those are topics of discussion. I'm just trying to figure out the best way to start so that we don't have to have 4 different bills on drones. That's all. Vice Chairman Washington.
Mr. Chairman, I think there's some merit to what you're suggesting, but I also think if we can get the ball rolling with a bill specific to correctional facilities, jails, et cetera, then if there are, at our next meeting, if there's a desire to move forward and make an omnibus drone bill, we could do that. But I think that we might want to start initially with individual bills and then see if we want to meld them together into an omnibus bill or maintain. There may be merit in bringing forward 4 separate bills.
So then you were the mover, right, Vice Chairman Washington? Okay, so your motion is regarding our correctional facilities.
Correct.
Okay, then let's stay on that motion. Mr. Fuller, did you have a question? Okay, all right. Yes, Senator French.
Just for discussion, I agree. Any drone going over correctional facilities, bad thing, but should there be a degree of offense? It's one thing if they fly over and drop a carton of cigarettes. It's another thing if they fly over and drop a pistol. Should there be something in it that says any lethal weapon has an enhanced penalty? Just throwing that out there.
Representative Craigo?
Mr. Chairman, do you mind if we ask Director Shannon a quick question on what, because I'm not sure what the penalty is. Is it a felony to drop
Cigarettes. over the fence.
cigarettes versus something else? I mean, I guess that would sort of, the use of the drone should be tied to the underlying crime. Whatever the underlying crime is, the use of the drone should probably be the same. So if it's a misdemeanor to drop cigarettes, then it's a misdemeanor to use the drone. If it's a felony, then to drop whatever, then it's a felony. I just don't know what the different levels of culpability are there.
Director Shannon? You help us out with contraband and
Mr. Chairman, committee members, Representative Prego, it would be no difference in variance if it was in the community. So it would be about the expedited cost of the value. There are laws with prohibited weapons, inside of our correctional facilities and detentions across our state. But as far as if it's a pack of cigarettes or it's a pistol, it would be a variance. It would be no different than if it was in the community.
so, but Director Shannon, sorry, that's a little confusing. So we don't have a general statute addressing the attempt or distribution of contraband inside of a facility?
Yeah,
So
we-
then
yes, we
it would be different because the cigarettes as the example versus a controlled substance.
Right.
Right. The controlled substance may be treated the same, but the cigarettes obviously is treated very differently in the community because now it's just based on age. Right.
Mr. Chairman, if I could,
That,
if I may rephrase that,
yeah.
it would be no different than in the community as far as having controlled substance, as far as tobacco, than if it was a narcotic, level of narcotic, things of that nature being introduced.
So then to Senator French's question, is there a difference whether it's a weapon or, I'm assuming?
Most certainly there is.
Okay. Mr. Fuller?
Yeah, Mr. Chairman, I can get it started. There is a statute for taking contraband into penal institutions. Contraband means a cell phone or electronic communications device, money, cigarettes, tools to facilitate escape, or any other item that the person can find is prohibited by law from making, obtaining, or possessing. That's a misdemeanor offense, punishable by up to 1 year or up to a $2,000 fine.
Additionally, Mr. Chairman, there are two separate statutes, one addressing that it's a felony to bring in a controlled substance or intoxicating liquor into a jail, state penal institution, boys school, etc. That's a 3-year felony. And then for taking a deadly weapon into those institutions is a 10-year felony.
So it sounds like, Mr. Mover, that you can, it's already illegal to do all of that, which is a little confusing why we've spent this much time on it, but apparently it's not illegal if I do it by a drone, and if I do it with my hand, it's illegal. So that's what we're clarifying. So it sounds like, Vice Chairman Washit, would you be amicable to just mirroring those penalties as a starting point?
Mr. Chairman, I think that we can wrestle with all the details after we see the bill draft, and we can develop this legislation further at that time. I just want to get a draft before us. We can tweak it however we wish when we get together in September.
Okay, so start there. Co-chairman, Nethercott, please.
Thank you, Mr. Co-Chairman. So I think that's prudent to follow the current statutory scheme. I also think it's important to capture the two concepts that we've discussed here today. One is broadening the scope of beyond just contraband, which is doing any kind of surveillance activity using a drone of a prison facility, period. You have safety concerns regarding it being people learning how it operates and who are the inmates inside of it. And the correctional workers as well. So that needs to be encompassed in as well as Representative Oakley's language associated with the ability for law enforcement and the correctional facility to capture that surveillance equipment, including a drone. Whatever they want to do with it, capture and disable.
Yeah, and Mr. Fuller, Director Shannon, I would assume that if I stood outside the yard with a camera filming, is there already a statute that addresses that? Or
Mr.
no?
Chairman, not that I'm aware of.
Okay, so that really, so then the chief, okay, so yeah, the chief differences here are really surveillance and it's really disabling the drone. Capturing the drone or disabling it.
Mr. Chairman, that's correct.
Okay.
Question?
Representatives want it.
Just making sure the co-chairman officially moved that to the, okay, so I'll second that. Is it a motion to amend or is the mover just?
I think the mover is just really amicable to anything here. Yep, that was adopted by the mover. All right, sensing a strong desire to vote from my co-chairman. All of those in favor, say aye. Aye. All of those opposed. All right, good job. Any other motions? Representative Rodriguez-Williams.
Thank you, Mr. Chairman. I move that we amend Wyoming Statute 233306 to include a definition of UASs, so defining unmanned aircraft and unmanned aircraft systems to the statute.
That's where.
Seconded, Representative Zornitzer.
Here's my concerns, because I think we heard from Game and Fish testify that they don't see there's a current issue with it. And I believe it's because we feel it's in the regulations. And so the question is, by putting it in statute, does that make it more or less flexible if there's some reason to change it, that the legislature has to go back and fix statute, or is Game and Fish easier to the commission to fix their regs? But does it carry the same weight? I think so. And so that, I think that's my discussion point. I kind of think it actually probably should be statutory, but it's probably more flexible as a regulation right now if we feel Game and Fish is adequately handling their own regulations. So some more discussion on that from anyone with a law degree.
Co-chairman. Oh, Representative.
Thank you, Mr. Chairman. I think it needs to be in statute. I don't have a law degree, but I think if departments and agencies are regulating it, I think the state needs to take a stance on it as well. I appreciate the language that's in South Dakota statute. And I think that there's some lessons learned from other states. If you read the document, there's some statutes that have been repealed, language amended, and
okay. Ready to vote? All those in favor signify by saying aye. Aye. All those opposed? Any additional motions? Yes, Senator Kolb.
Thank you, Mr. Co-Chairman. I'd like to entertain the idea or entertain a bill draft for the purposes of the expectation of privacy when it comes to drones and explore that. I think it's becoming a huge problem.
Mr. Co-Chair?
I heard a second. Second. Okay, go ahead. Co-Chairman Ethica.
That might, Mr. Co-Chairman, be consistent with the concepts within Section 159 of the Restatement Second of Torts.
Senator Kolb or Representative Zwanzer, do you have a starting place on where you think that a privacy bill would begin?
I do, Mr. Chairman. So LSO testified earlier that it was murky, but there were some statutes when it came to personal enjoyment that could be used. And so perhaps a starting place is to specifically incorporate those sections into a misdemeanor or restate them to the point that it's more clear. And maybe Mr. Hopkinson could make what I just said more clear, because it's been about an hour and a half, but there were some sections that could potentially be used. If we can specify those sections apply, I think that'd be a great starting place.
Mr. Hopkinson?
Thank you, Mr. Chairman. And so I think there are two separate questions here. One with, do we want to incorporate section 159 on page 5 of that memo? The language is there. Do we want to make that criminal? And then there was the other language specific to just prohibiting, okay, there it is. On page 6, there's the common law tort of intrusion of seclusion. So which one are you wanting us to look at there? You know, the intrusion on seclusion is just one who intentionally intrudes physically or otherwise upon the solitude or seclusion, is subject to liability, making that kind of language criminal where it's just that intrusion on the solitude, or specifically looking at that 159 language, which is dealing with if it enters into the immediate airspace and it interferes substantially with your use and enjoyment of the land. That one may be a little more clear. But for clarification, I would ask, are you looking for criminal penalties there, or just to codify the civil side?
Senator Cole?
Thank you, Mr. Co-Chairman. More clear, intrusion. I think some way that I don't want to run afoul of the FAA. Obviously, there's an issue there with them. I thought possibly you could categorize it as your personal space. Some way of not talking about, frankly, airspace, and in drafting it in a way that we could be clever and get around a conflict. Thank you, Mr. Co-Chair.
Mr. Hopkinson?
And to clarify, you are wanting that to be a criminal violation, and if so, were you looking for a misdemeanor or a felony or some sort of enhancement if they're doing it multiple times? What were you looking for on that?
Senator Cole?
Thank you, Mr. Co-Chair. All the above. I think that needs to have discussion, just to find out, explore what is reasonable for a type of penalty. But I think obviously this is new and we have to, handle it as such.
Does all of the above include capital punishment, or?
Drone battles. No, I think excluding capital.
Okay,
good. Chair.
Just clarifying. All right.
Mr. Chairman,
Representative
if it's a good starting place, first offense, misdemeanor standard, and then second or subsequent offenses would be felony level. It's probably a good place to start the draft. Unless Representative Oakley disagrees with me here.
Representative Oakley and then Senator French.
Thank you, Mr. Chair. I guess I would push back. I know, we're talking about this, but you are looking at, farm is nuisance. I don't know, we have shoplifting in our food. I don't know that we're being annoyed by it's policy discussion, but I think it's definitely.
Oh, Representative Oakley, your trees one day will be filled with drones too. You just have to serve long enough. Shoot it on the second offense. Senator French. French.
Thank you, Mr. Chairman. In this, we need to, this is just for discussion, this privacy, you're out there on the land and somebody flies a drone over, and I don't know how many of you in this room have ever had a horse, but it's your friend, it's your companion, it's your pet. And when that horse gets old, it can look pretty rough. It can look, and you've done everything, you've babied that thing for 25 years, and it's at the end of its life. Well, somebody flying a drone and then they report that, oh, they're abusing that animal, then you're in the system, and it can cost you a lot of money to get out of that system to prove that, hey, it's an old horse and it's at the end of its life. I'm not mistreating the thing and blah, blah, blah. So just something for everybody to keep in mind, we might, there's a broader aspect to this thing. So thank you.
Senator Cole?
Thank you, Mr. Co-Chair. I think I was thinking more along the lines of voyeurism. flying a drone. They could have taken, explicit pictures, posting them on the internet. I think there's a lot of things here that can be done with this new technology that obviously most people wouldn't do, but there's always a few bad actors out there that are certainly willing to do. So that is why I thought it had to have needed a higher level of a penalty than say shoplifting. That certain pictures on the internet live forever. And I think people need to be protected with this new technology. And it is new. But I think it's definitely something that has to be tackled and at least worked on. So I think enhanced penalties are justified for the type of things you could do and can do with a drone. So thank you, Mr. Co-Chairman.
Mr. Hopkinson.
Thank you, Mr. Chairman. And Senator Kolb, I guess one question I would have then, the way I'm conceiving it being drafted at this point is related primarily to trespass. The current voyeurism laws may be applicable already. I haven't taken a close look at that because that was kind of outside the scope of what I was looking at with trespass and drones. But I'd certainly be happy to provide more information to the committee related specifically to voyeurism, because I think those laws, if you're using your drone to take pictures through someone's bathroom window, for example, I think that's already covered. And so I guess just to clarify, are you wanting me to focus on the voyeurism side of things in this bill draft, or is that something we'd like to address later and focus more on trespass in this draft?
Senator Cope.
Thank you, Mr. Co-Chairman. Obviously, I want to make sure there's no loopholes. Okay, that's really the main concern. I was thinking also along the lines of people just meandering around your own backyard. Wherever you have a reasonable expectation of having privacy, I don't believe that folks should have the expectation of taking that. And I think if we draft language around, that being some sort of a penalty for doing such a thing, I think that was what I was, in my mind, wishing to do. There's no loopholes. So we make sure we have our bases covered.
David, I think for our next meeting, what we're looking at is a criminal trespass bill. And then I don't know what you'll find that you may not have already found, but looking at some other states, if they do have any enhanced penalties for any particular use of a drone, that would fit Senator Kolb's, if it's voyeurism, it's a enhanced penalty. I don't know what else the list would be that he's thinking of, but I think if you at least start there, there's a lot, it sounds like we can discuss with this. So once we have something in front of us and a little better idea of what other states might do or might not do, then we kind of know what's on the table as options. I think maybe that's where we should start. Okay. Any other discussion on this bill draft? Yeah, Representative Grego.
Thank you, Mr. Chairman. I guess I'm just trying to maybe muddy the waters or unmuddy the waters. I'm not sure which. I mean, so are we really, so criminal trespass is probably going to require some sort of height requirement restriction to get, I don't know how we define criminal trespass, or are we really talking about unlawful surveillance? I mean, I think, that's where I'm in my mind trying to figure out which path do we go down? I mean, they maybe get us to the same spot in the end, but unlawful surveillance wouldn't necessarily require a height restriction. I mean, we could put that in there, but some of the other states, you look at like South Dakota, North Dakota, that's how they've addressed it, is you can't surveil private property. Private person can't fly over to their neighbors and surveil their private property with a drone. Does that work? I mean, that doesn't address harassment elsewhere either. I mean, out on public property, that's a whole separate issue as well that maybe we need to address at some point as we go through this process. But I'm just throwing that out there. I don't really know which direction we're going.
Representative Zornitzer.
Perhaps, so in response to that, I mean, surveillance, I think you could get into the felonies. Where I thought the motion was going was, you don't have to even take photos. If you have a drone on someone's property and you're impeding their quality of life, or, I mean, you're not going to know if there's a drone, if it's videotaping you or just standard photos, or harassing your cows, looking for a coyote. I mean, whatever it is, you don't know at the time, and having to go through that investigative process is going to be a lot on proving elements. So
yeah, I think Representatives wants are right. If we're looking at 159 just as a guidepost, that it's simply entering the airspace above somebody else's land is a trespass. We're saying that's a criminal trespass in the bill. Maybe that's your misdemeanor, I don't know. And then maybe your felony, whatever occurs when you do these other activities that Senator Kolb is talking about that you're referencing, surveillance, what type of surveillance is it? I think that obviously matters too, but obviously those are things that we have to work through. And when we have the bill draft in front of us, I think the airspace you can work through that if you're concerned with a footage concept, Representative Craigo, but I think we just have to get the concept in front of us and then decide how workable is it.
Mr. Co-Chairman?
Yeah, go ahead.
Great. And I don't know if this has been done because it's been a little convoluted, but I would move for a bill draft adopting section 159 as a misdemeanor trespass statute for addressing drones, just as a starting working place. We'll just keep it as a misdemeanor for now. Is that, no, confused?
Mr. Chairman, I guess I don't know that we've resolved Senator Kolb's motion, so I'm trying to figure out where we're at in the strategy.
Me too. I just want to back that.
We just want to, Senator Kolb, are you amicable to just backing that up to a starting place of 159 as the statute as Senator Nethercott has explained? As a misdemeanor?
Reluctantly, yes.
All right.
As a starting point, but we've got to do more than just a misdemeanor, I believe, in a lot of cases. Thank you.
Yeah, so David, I think that's where we're at. 159, that's your misdemeanor. You can look at if any other states at all have any type of enhancement for any type of activity that takes place. And I think that addresses Senator Kolb's desire to make sure there's no loopholes. And so we're back on the original motion that has been amended. Any other, well, we have the original second on the motion. Who was Representative Swanson? We're now on your motion inside of Senator Kolb's motion. Any other discussion? All right, all those in favor signify by saying aye. All those opposed? All right, any other motions? Anything else that we could possibly do with drones? Yes.
Mr. Chairman, I may have misspoke in my motion earlier where I referenced Alabama. Going back through the information that was provided, well, my original statement about California, where it stated California does in fact have a specific penal code relative to that topic, does not appear that the state of Alabama does. So I would just ask that the general conversation about what we needed to accomplish with that probably should not be based on a Alabama statute that doesn't exist.
All right. Any other motions? Motion to send drones to another committee. That's your chance now. All right. We already, I'm confusing myself now. We already have your 103 motion. So now any other motions on trespass at all? Yes, Co-Chairman Nethercott.
Thank you, Mr. Co-Chairman. I think to address Senator Kolb's point, this might be too much. It's our first meeting of the interim, so it's a little rough for us, but so we'll have the bill draft addressing section 159 of the restatement, right, as we just passed. But then if we could get a memo from LSO evaluating how drones can be used for the crime of voyeurism and the concepts associated with that, recognizing that voyeurism really is associated with you being in a place where you have an expectation of privacy, such as inside your home, and it's limited to that, or in a dressing room, but it's not in your backyard. So the crime of voyeurism would not be triggered by a drone taking photos of you in your backyard. So that or underneath your clothes, right? It's just, I think what we're also trying to expand the scope of, and what the memo hopefully can maybe do, is to understand how other states or other concepts might be triggered for how I think we as Wyomingites probably don't want drones taking photos of your families in your backyards or doing whatever it is you do on your property, where there may be a greater expectation or a reduced expectation of privacy, but still an expectation that would exist on one's own land.
Okay. Representative Rodriguez Williams.
Thank you, Mr. Chairman. Just to follow up, I'd like to make a motion for a request from LSO as well, if this is needed or not, but under Title VI. So we passed a motion to define aircraft under Title 23, but I'm curious if it's needed under Title VI as well. Specifically, we define vehicle when it comes to like transporting drugs and things like that. But if we need to include a definition of UAS as well in that, specifically under 61104.
Okay, Brian. Or Mr. Hopkinson. Do you understand what you'd be looking at?
Yep. So Mr. Chairman, is it a motion just for like a memo or, okay. Yep.
Okay. Perfect. All right, committee, anything else? All right. We will close the topic of trespass and drones. All right, here's the deal. When Co-Chairman Nethercott wrote this agenda, she purposely left out breaks. So, and I actually thought we would take a break around 10:30, but here's the deal. We have a lunch scheduled at 12:15. We're not that far away from our lunch. So if my proposal would be, we just power through, get as far into vulnerable adults as we can go for the next, 30 minutes and then go to lunch. All right. With that, we have Senate File 76. Hold on, let me see. Actually, Mr. Fuller, you have a memo. Other states' laws prohibiting violence against, nope, that's our second half of this subject. Okay, so we'll start with Senate File 76 then. Sorry, Senator Case, come on up. Welcome to Lander, Senator Case.
I love this town. Thank you, Mr. Chairman. Welcome to all of you. Thank you very much. Let me just dive in. Mr. Chairman, I had a bill in the last session. It was Senate File 76, financial exploitation of vulnerable adults. It's the bill passed through the Senate and the House committee and died on general file in the House. I think what really kind of messed it up was an amendment that was offered in committee of the whole that kind of messed everything up a bit. But with your permission, I'd like to go through the bill real quick. The bill ties in the adult protection statute and the banking statutes. And what it does is, if you think about your relationship with banks in Wyoming, and probably in Wyoming more than other places, people who work in banks and you have an account there for all these years, they know you very well. And as you get a little older, perhaps, or you become vulnerable in some ways, people in banks might recognize some things that are happening. And with the right legislation, we might be able to prevent adults from being, vulnerable people from being scammed. And you hear about these scams all the time. You hear about people that surrender money to caregivers, to acquaintances. It goes on the internet. You just name it. Ordinary people are very vulnerable, but these people who might be elderly or otherwise challenged could be even more vulnerable. So what this basically does, the bill just says, hey, banks, if you're aware or suspect this, do something about it. And it protects the people's assets. It protects the banks and the other financial institutions if they say, you know, Mrs. Jones has been here last Friday. There was someone with her that was strange. They did something unusual about her accounts. Could we check this out? Could we talk to Mrs. Jones' kid in Texas and see if this was a legitimate transaction or not? You know, she hasn't been feeling well. These kind of neighborly things. It sounds kind of simple, and I suppose banks do it already, but there are consequences. They're not really required to do it. You have employees that may feel that they don't have an obligation to do it or that they shouldn't do it. This kind of clears up that, Mr. Chairman. So the section 1 of the bill goes into the banking statute, which is Title 13, banks, banking and finance. And it talks about the makes it a crime. And so this is the section 13, 401 through 406 are created, and it defines the department, being the Department of Family Services, what exploitation is. It means the act of forcing, compelling, or exerting undue influence over a person, causing the person to act in a way that is inconsistent with the person's relevant past behavior, or causing the person to perform services for the benefit of another person. Financial exploitation is defined. It's the wrongful or unauthorized taking, withholding, appropriation, or use of the money, assets, or other property of the person. It could be an act or omission by a person, including the use of a power of attorney that could be used to, 1, obtain control, 2, convert money. Financial institutions are defined on lines 17 through 19. Those include credit unions, I might add. Vulnerable adult is defined in 352102. That's the adult protection statute. And on page 4, 1310-402, this is the new language. And this is kind of the crux of the bill. If an employee of a financial institution has cause to believe that financial exploitation of a vulnerable adult has occurred, is occurring, or has been attempted, the employee shall, that's a deliberate shall, notify the financial institution of the suspected financial exploitation. Part B, lines 10 on, covers what the financial institution then has to do. If the financial institution is notified of the suspected financial exploitation under Part A, or otherwise has cause to believe that financial exploitation of a vulnerable adult has occurred, is occurring, or has been attempted, the financial institution shall assess the suspected financial exploitation and submit a report to the department, that being the Department of Family Services, in the same manner as and containing the same information required to be included in a report under WS 35-2103. And by the way, that is in the adult protections statute, and that is the report of abuse, neglect, exploitation, and the list goes on. The financial institution shall submit the report required by this subsection not later than the earlier of the date that it completes the own internal assessment, or 5 business days after the suspected event has occurred. Lines 12 through 18 on page 5. This wraps it up for the financial institution. It says a financial institution that submits a report to the department of suspected financial exploitation of a vulnerable adult under subsection B, we were just in there, of this section, is not required to make any additional report of suspected abuse for the same conduct. Part D requires that financial institutions to come up with internal policies, programs, plans, or procedures to accomplish this. Many of them already have things that are very close to that already. And those reports should cover the employees and the assessment required earlier. Lines 9 through 15, the policies, programs, plans, or procedures adopted under subsection D of the section may authorize the financial institution to report the suspected financial exploitation to other appropriate agencies and entities in addition to the Department of Family Services, including the Wyoming Attorney General, Federal Trade Commission, and any appropriate law enforcement agency. 1310-403, this is about notifying third parties of suspected financial exploitation. If a financial institution submits a report of suspected financial exploitation of a vulnerable adult to the department under this article, the financial institution may, it's not a shall, at the same time, at the time the financial institution submits the report, also notify a third party reasonably associated with the vulnerable adult of the suspected financial exploitation. And that occurs unless the financial institution suspects that the third party, and this could be relative, caregiver, is actually part of the exploitation. 1310-404, this provides the ability for there to be a small temporary hold short on the financial transaction. And it gives the bank the ability to actually protect people's money. So notwithstanding any other law, a financial institution may place a hold on any transaction that involves an account of a vulnerable adult if the financial institution submits the report, has cause to believe the transaction is related to the suspected financial exploitation. And under B, it I wonder if I'm missing. Oh, I'm sorry. A and B both occur under Romanet I, then Romanet II. The financial institution shall place a hold on any transaction involving an account of a vulnerable adult if the hold is requested by the Department of Family Services or a law enforcement agency. Part B, subject to the subsection C of this section, a hold placed on any transaction shall expire in 10 business days. And just to clear that up slightly, there was a House committee amendment, committee of the whole amendment. I'm sorry, it was a standing committee amendment that changed that language to say placed on any transaction under subsection A of this section shall not exceed 10 business days. So you could have a shorter hold, which makes total sense. Part C is for a longer hold, and you may extend a hold, but only if it's requested by a state or federal agency or a law enforcement agency. So that would be to extend the hold longer than 10 days. Page 9, part D at the top of the page just says they have to adopt procedures. 3510-405. This is the part that the financial institutions want, of course. It's immunity. They do things right. They're not, they're immune from any civil or criminal liability. So basically, if an employee suspects something, the bank makes a report, they follow the law, then lines 15, they would be immune from any civil or criminal liability arising from the notification, report, testimony, or participation in the judicial proceeding unless the employee or financial institution acted in bad faith. So part B is the same. A financial institution that in good faith and with the exercise of reasonable care places or does not place a hold shall enjoy that immunity as well. 1310-406 is about records. Section 2 is about authorizing the Department of Family Services to promulgate rules. Section 3 was the effective date, which would be in about 2 weeks, and I don't think that's, or about a month and a half, and that's not going to happen. So that is the bill. There was in the first committee, which was the Labor Health Committee, I'm sorry, the first committee was the Revenue Committee, and Senator Baldwin was the acting chairman. There was a motion to, on page 7, line 13, we get there. It's at Romanet I and lines 12 through 14 on page 7. And it's says may place a hold on any transaction that involves an account of a vulnerable adult or the new language, or that contains the vulnerable adult's assets or property. So that was from the first standing committee. Be happy to answer any questions. The bill came about because I was requested by the banks and the credit unions. They all joined together on this one, believe it or not. And I believe that Mr. Meyer from the Bankers Association is here. He's also a Lander boy, as is not a boy, but Ms. Oakley is a Lander girl.
Chairman Case.
Not to be confused with a Riverton girl at the front of the table, Mr. Chairman.
Wow.
Go ahead, I'm sorry, Mr. Chairman.
Is it 30, 25 miles, 30 miles between?
Seems like 1,000 miles sometimes, but we're really right next to each other.
I think this topic is also being approached by Labor and Health over the interim. Is that accurate, or did they fully punt it to us?
I don't know the answer to that. I'm not aware of that.
Okay. Yeah, when I thought I remembered something about that, but as I'm staring at their interim topics, it doesn't look like they are dealing with it at all. It's us. Okay. All right. That was gonna be my question, is where are they at in that process, which is nowhere. All right.
Maybe you could trade this for drones.
Representative Provenza.
Thank you, Mr. Chairman. Thank you, Senator Case. Looking at page 9 on the immunity, on line 11, it has the word or, so correct me if I'm wrong in reading this, I guess is my question. I'm trying to understand if the bank then, or the financial institution submits a report under what is above or provides notification to a third party. Does that mean that if the bank tells a family member, hey, I think this might be going on, that they then are no longer held liable, perhaps in civil actions, even, with good faith? Does that make sense?
It does, Mr. Chairman and Representative. I think that's correct. I think the or applies. Those are two forms of making people aware of adult or of vulnerable adults. Those are both in. So I think that, yes, that or stands, and it either way triggers the immunity. And there's even another one. If they go down farther, there's another or talks about participating in a judicial proceeding.
Co-chairman.
Thank you, Mr. Co-chairman. Good to see you, Senator Case. What is the source of this bill? Is there a uniform bill going around? Is this being passed in other states? And is there a specific incident that came from our financial institutions regarding this issue? Because as you recall, my concern in the session was this is wholly unnecessary and may in fact complicate an actual case of financial exploitation, but we'll get to that. So what is the origins of how this bill has been drafted? And then secondly, has there been a concern from a Wyoming financial institution that has triggered this today?
Mr. Chairman, Madam Co-Chairman, the answer to the second part is yes. The banks were there and testified. Mr. Tom Bass testified about instances within their banks. Other people talked about areas that this would improve relations with clients and give banks tools that they need. Whether or not it's a uniform bill, there are similar things being pursued across the country. I don't think there's a uniform act, so to speak, not as I'm used to thinking of a uniform act. But Mr. Meyer is here and can testify to these things.
Co-chairman Endicott.
Thank you, Mr. Co-chairman. So I would just say, isn't it true that if a financial institution believes that criminal activity is occurring or that one of their members is experiencing criminal activity through exploitation, that they do have the ability to confidentially inform DFS of that concern, and DFS then has an obligation to investigate?
certainly, Mr. Chairman, Madam Co-Chairman, you know, if banks believe a crime's being committed, they have an obligation to, you know, to come forward and, you know, not assist in crime. This sort of bill kind of relates to the more the gray areas. And it relates more down to the employee level. And if you think about it, you never really know. You never really know if Mrs. Jones is being exploited or not. You want to be on the safe side, but but there are consequences to that as well. This says we're going to be safe rather than sorry. We're going to protect our employees, and we're going to protect the bank by trying to do the best thing we can. I live in a small town, and you're welcome to be here with me. I spend a lot of time in the banks. I can just see this in practice. I can feel it in practice. The tellers know people. They know them either personally or by phone. You know when something's off. Not every time, but there's something really weird. You know, a certain person has changed. They become a little more confused, and there's a chance they're being taken advantage of in this situation. People in our small towns know that. Yes, it's a bit nosy. Yes, it's a bit kind of a violation of privacy. It might even be a bit cumbersome in terms of the financial holds and things. I think this is a good common sense solution. I really do. Kind of in the middle. And I don't see where it does any harm.
Senator Cole.
Thank you, Mr. Co-Chairman. Well, still good morning. Senator
Good morning.
Case. I am really concerned about the implications this has for the tellers. Just those folks, they become judge and jury of a suspected issue, what they think maybe something's going on. And I'll grant you, there's probably a lot of very good natured people out there that do have a feeling of what's going on. But I am quite afraid that in this current woke society we're all facing, we're going to get people in there doing things that frankly they should or shouldn't do. And the liability for those people, because let's just say there was a problem and they didn't report a problem, they could face a legal challenge by the people who were, say, defrauded, and that they didn't alert the right people for whatever reasons at the right time. And we're putting them in an awkward place, almost like police officers. What training do they have? I mean, besides their good sense, what training do they have to identify things like this? Because I'm afraid that really good criminals are really good criminals, and they fool a lot of folks, a lot of good people. But I just don't know if this is the right fit to protect people. Yes, I think there's a benefit, but I think there's a risk also to people. And I'm concerned about that risk. And if maybe you could address that risk and maybe how it can be mitigated, I'd appreciate hearing that. Thank you, Senator Case. Thank you, Mr. Co-Chairman.
Mr. Chairman, Senator Colby, I actually think it does the opposite, because by providing it the immunity, it clears up this gray area about whether you should say something or not. And really, what's the worst that can happen if you say something and you say, I'm worried about this transaction. What is the worst that can happen? The transaction doesn't go through. Someone says there appears to be something wrong. Let's check it out. In the worst case scenario, it could be 10-day delay. I agree that is very significant. And but in the most modest of cases and the most likely cases, a call to a relative, just a little bit, obtaining some more information might well clear it up. I think it does the opposite. Rather than making, it empowers employees to protect their customers that they know very well.
Co-Chairman.
Thank you, Mr. Co-Chairman. Thank you, Senator Kasich. So to my question of has this happened in Wyoming institutions, I'm not a member of the Revenue Committee, so I missed that testimony. But certainly, yes, exploitation of vulnerable adults through financial institutions is occurring and has always occurred in this state, and they're aware of that. So it's not my question of whether or not there's financial exploitation of banking customers is occurring in the state. The question is, why are they asking for immunity for participation in the reporting of that crime when they're aware of it? What has triggered the request for immunity?
Mr. Chairman, Madam Co-Chair, I think might be the best person to ask that to is the Scott Meyer from the Bankers Association, who's here to testify. I think maybe he could do a better job than I can on that. But I will say that I think there's comfort in the immunity. And, you know, I know that doesn't matter much to you, but we're in a world where people stay out of other people's business. It's become that. And I think we've lost some because of that. So if a teller is afraid to bring something up because they think they're going to get in trouble, even though there might be a crime, we've done more damage. So it's two sides of the same.
Mr. Co-Chairman?
Yes.
So my question is, has a teller ever been in trouble or any other bank for reporting a crime of financial exploitation to the Department of Family Services, that they would need some type of an immunity coverage, both civil and criminal? And if that logic applies, shouldn't everyone in the state of Wyoming receive immunity coverage for suspected exploitation of a vulnerable adult in order to encourage the reporting? And where does it end?
So, Mr. Chairman, I cannot answer that question, whether a teller ever, I just can't answer that. You can ask that of Mr. Meyer, maybe he can. I can tell you that the opposite is where the problem is where you don't say anything because you're afraid something might happen. That's where the problem is. So the teller that watches the suspicious person accompanying Mrs. Jones in as they empty her savings account and then walks out the door and says, well, you know, I don't want to get in trouble. Don't want to mess with that one. And I think that's the worst problem.
Representative Oakley.
Thank you, Mr. Chair. Good afternoon, Senator Case.
Good afternoon.
My question, so obviously the shall is as you discussed, big part of this bill. Would you be like vehemently opposed to the changing of shall to may for those situations maybe where they don't feel like they have enough evidence? Like maybe they had what you said, the good sense or a hunch, but not enough to feel like they report it, but where this might make them feel compelled to report it. Or I'm interested in what Senator Kolb said, maybe there's people who aren't trained, you know, lower level, who we shouldn't be trying to compel to report this. Or in essence, do you think that guts your bill?
Mr. Chairman, Representative Oakley, I'm just looking, I think we have to keep the shall at the level of the employee. And it has to be the bank's policy that you have to do that. The next shall is on line 15 of page 4. And it says, basically that comes about and says that the bank shall assess. I think the bank could decide at that time that it doesn't warrant. They looked into it. And how'd they look into it? Well, they called Mrs. Jones' daughter. She lives in Texas now. And she said, verified the story. Or, you know, that's kind of part of the assessment, I think. So I don't see those as being, the one for the employee is pretty hard and fast, I guess. But the one for the bank, it says they shall assess. And that if their assessment says there's exploitation, then it goes on. So I'm comfortable with them. The may sounds pretty squishy in those instances.
Representative Crago and then Representative Provenza.
Thank you, Mr. Chairman, Senator. So as I'm reading the immunity, because that's one of my big questions on the bill too. I mean, it's a one-way street. So it does not protect the bank teller who's doesn't report. Even though, you know, we get into these circumstances where the teller, for example, maybe has a, you know, hair on the back of his or her neck stands up a little bit, but they have no other proof, right? And they don't report it. And it doesn't provide immunity for that particular person. And so are we going to create a situation, this is my question to you, we're going to create a situation where every time somebody comes in, we're just going to, and it has to do with an elderly or person, vulnerable adult, that we're going to have lots more reporting. And so I don't know what the statistics are from other states where this law is in place, but are we going to run into a situation where the immunity language as written creates a lot of problems for our local DFS agents who are trying to, you know, every day they're responding to one of the banks in town to dig into one of these situations?
Mr. Chairman, Representative Craigo, thank you for the question. I don't think that it's going to create more problems. I mean, if you don't, right now, if you don't say anything, that's where it is. And you don't get immunity for not saying anything. So I don't even see that coming into play. If you do say something, you know, I guess your question suggests that people might overly report to overly enjoy immunity, but they don't get an immunity now, and there's no consequences. I just do not see that playing out, and I think that there's probably under-reporting now. And it's just the kind of world we are. So a little bit more reporting might be a good thing. We might protect people's assets. We might help vulnerable adults, and I think that's probably a good thing. I don't see it being overboard.
Representative Craigo.
Follow up, Mr. Chairman. Senator, I guess right now we don't necessarily have a duty to report. And so is there underreporting? Yes. But if this legislation was to pass, we then do have a duty. And so I guess we're shifting the paradigm a little bit. And that's what I'm concerned with is the people that are, you know, the forefront of the bank, when they walk in, they're going to be forced to make a lot of really tough decisions on a daily basis. And that's what I'm trying to, I mean, I don't know if we can change the immunity language to where if you don't report, I mean, I understand we're trying to get reporting, but are we going to be over reporting? Are we going to be putting people in a lot of stressful situations? They're dealing with, as you pointed out, they're dealing with people they know on a daily basis. And so they may have a good reason to not report, even though they, you know, you get into family dynamics. You start dealing with sons and daughters of a, you know, elderly person, and they're trying to decide which kid is trying to help mom or dad, and they don't know. The lack of immunity for not reporting, you know, we're creating a standard that's what concerns me as the bill's drafted. We're just putting some people in some really difficult positions that they may not be trained or paid enough money to be making those kinds of calls.
Mr. Chairman, Representative Craigo, well, I do think there'll be more reporting. I think this actually gives peace of mind to employees. You know, now it's clear, yes, we do this and there's good reasons to make the bank aware of things. Doesn't mean that there's going to be this full-on investigation of everything. I think that's maybe what people are afraid of. It just means we're just going to take a little bit more time with this transaction and maybe look more for a pattern. Could it be? And the statistics of people getting ripped off are way out there. And I would bet you folks that practice law or a prosecutor, you hear about this all the time. What great tragedies.
Representative Provenza.
Thank you, Mr. Chairman. Under record, so we're talking about potentially having more reporting. And earlier you mentioned concerns of privacy. And so on page 10, talks about the financial institution shall provide on request access to or copies of records and so forth. And so part of my concern with this, and maybe it's unwarranted, and correct me if there's a place for that, but what about, I mean, is this removing a requirement that otherwise would need, say, a warrant to get that information? So the bank can just hand over for a simple request without any of the protections that we get from our Fourth Amendment and so forth. So is that going to be, does this section right here just kind of require producing documents that otherwise right now would maybe require a warrant?
Mr. Chairman, I really hadn't thought about that. I think when law enforcement now is doing these investigations and a bank is cooperating with investigations, I'm not sure what the standard for warrant or not is. So that's probably something we should ask. I think Mr. Meyer might be able to help us with that. I also note that the director of the Department of Family Services is here, and she may know more about that too. I see your point. I definitely see your point, and it concerns me some, so I'd like to get the answer to.
Representative Lawrence.
Thank you, Mr. Chairman, and I hope I'm not going backwards here. But can we talk about the term vulnerable adult and why we're specifying? I mean, I hear every day of super smart, intelligent people who get some email to their kids, in jail in some other place, and they were dumb enough to, send money. And so what's the difference of why we're using vulnerable adult and going through DFS then instead of giving, our financial institutions, if they think that someone's being taken advantage of, that automatically qualifies someone as a vulnerable adult? I'm not totally making the connection. And if we could back up to, yes, I understand, it's the senior citizen, but there's lots of other cases out there. And so by categorizing this, it concerns me. And we go back to how we quantify what a vulnerable adult is based on, I know the definition, but why the segmentation? Why not just allow anytime we think someone's being taken advantage of for any number of reasons or complaining to the teller? We wanted to have that same type of qualified if this bill goes all the way through.
Mr. Chairman, another great question. Representative Zawanis, sir, I think we're tying it to the adult protection statute because that's where the reporting already is. And I guess our laws generally recognize that we need to take special care of some people for characteristics that they have or have come to have. And so that's why we have an entire statute there. This is not suddenly looking at every customer or every time you open an email, you fall into this statute because someone's trying to bilk you out of money. This is about these very special people that have either elderly, and there is definitely a definition of vulnerable adult, and I think it's good because it narrows that kind of a person and brings Department of Family Services in. They don't come in unless it's this abuse or neglect thing. So they're not triggered under ordinary investigations. And the director's here and she can explain how their law works. But yeah, am I going a far afield? I suspect I am.
Well, no, I think great center case, and good afternoon to you, fellow co-chair. Is there a possibility then, and maybe it's for the financial institutions, if there are people who we already know are vulnerable adults, can we do something proactive in those financial institutions? Their kids can say, put a check mark, or everybody who's in a trust or a guardianship situation has that kind of extra. I don't know if that invades personal privacy, but one side of the equation I'm not understanding. So if this is a segment of the population we need to be concerned about, is there a way to proactively let the financial institutions know that we're a little concerned about them managing their own finances, and if they're growing over a certain amount, or if something seems awry, have a little extra care. I mean, that's what we do for senior citizens driving on the roads. We have some kind of, I like to think, subtle backwards ways of having ways to ensure they can continue driving. So if that's what we're concerned about, is there something on the other end to tag those accounts when they get set up, saying these are for individuals, or is that also an invasion of privacy?
Mr. Chairman. So I think we do a little bit of that already. I mean, you have cosigner. Grandma has a cosigner with so-and-so, and that kind of way people take care of that. If we could, I'd like to go back to the statute and just read what a vulnerable adult is. And it's in the definitions of 3520-102. And it says a vulnerable adult means any person 18 years of age or older that is unable to manage and take care of himself or his money, assets, or property without assistance as a result of advanced age or physical or mental disability. So we're kind of talking about a special class. I think in terms of the customers that you see in a bank, you're seeing people that transition. It's not normally someone that has an intellectual disability, for example, where there's a cosigner on their account and someone manages things for them. That one's pretty clear. I think in the case of the elderly and advancing age is where it gets a little bit squishy, because we all get to a point where maybe we need a little help with our affairs. Maybe we become vulnerable. And I'm sure the Department of Family Service could talk to us a lot more about what this means, but that's really probably what we're talking about. Or maybe someone has an illness and they're not that advanced age, but they have an illness that creates this level of vulnerability. So yes, there could be like advanced directives. When Mrs. Jones is allowed to withdraw $50, no more than that. And if so-and-so comes in, don't let them do it. Sure, there could be all those kind of things, but this is kind of the catch-all, I think.
Co-chairman Nethercott.
Thank you, Mr. Co-Chair. When looking at the definition of a vulnerable adult here, I think it's important for the committee to consider whether or not we need to update the statute. Advanced age means a person who is 60 years of age or older.
Clearly, we need to update it.
All the institutions to update that, the Wyoming legislature just might be equipped to find the right age.
Mr. Chairman, I know that there are other people here to testify too.
Yes,
So,
and there's lunch.
yeah.
Any other further questions for Chairman Case? If not, it is a perfect moment for us to pause and break for lunch. And we'll be back at 1:30. When we do come back, we will hear from Mr. Meyer. Your name was obviously raised. We will hear from the department. We will hear from, I believe, Mr. Laycock here also on our agenda for this topic. And we will catch up and be on schedule. I am confident of that. And yeah, the afternoon is definitely lighter and more flexible. So